Okay. Is there any mentioning? If not, then should we start, sir?
Yes, please go ahead.
Okay. Item number 1, item number 2, and item number 3. It's Mechamedi HPP India Private Limited.
Lordship, Mr. Nagesh was held up in traffic. He's just downstairs. He'll
So
hardly
is
take a
Mr.
minute to reach upstairs.
Sure, we'll wait for them, not an issue.
Obliged, Lordship.
Yeah, in the meanwhile, just can you, madam, go through that list of dates, because you take your file.
Yes,
You have the list of dates.
Yes, Your Honor.
Is it a common set of dates which you have given? This one?
List of dates is separate, Lordship.
The
The
convenience
compilation is common.
Okay. Now let's see the prayer in both your petitions. We go through that.
188 का दो, 188 का दो.
Your Honor wants me to read the final relief in both petitions.
Yes, you have filed 2 CPs, right?
Your Honor, we have filed CP 35 of 2020.
CP 188.
For Your Honor's
188.
convenience, we had also circulated a convenience compilation which is by Flowell Volume 2, in which we've reproduced the relief and the memo of parties in all 3 company petitions, if that is convenient for Your Honor.
35 minutes.
Otherwise, Lordships can have it in the petition copy itself.
Whatever is convenient.
Sure,
Your
sure.
Honor.
Now let's look into what is relevant and then we take it.
Obliged.
In your convenience compilation,
Yes,
where
Your
is the petition of Flowell, the relief which they have sought?
Your Honor, we have filed a convenience compilation which is Volume 2. Does Your Honor have Volume 2? There were 2 volumes we had submitted. One was of documents, which thereafter we withdrew because there was a common convenience compilation. And then there is a Volume 2 in which we have reproduced the memo of parties in all 3 petitions and the relief in all 3 petitions. We had also made a comparison of the allegations of oppression mismanagement and the reply.
Probably, Lordship, something like this.
Just show it to her. Show it to her.
Ma'am, volume 2?
Volume 2.
Volume 2.
Flowell?
Please, Your Honor. CP 35 is on behalf of Flowell.
Madam Nirmala, will you ask him to understand what is written?
Your Honor, the interim reliefs for CP 35 start at page 31 of this compilation.
Volume 2.
Can you
Volume
read? I said not pressed. Please read what is written on top.
33 is final relief.
This is the one.
First.
Which line, madam?
Your Honor, page 33 of volume 2 is the final relief of CP 35.
Yes.
Does Your Honor have it?
Please read it.
A is declared that the respondents have conducted the affairs of respondent number 1 in a manner oppressive and unfairly prejudicial to the petitioners. B, confirm the interim release in terms of interim prayer. C, and declare that the failure of the respondents to rectify the register of members of R1 company to include petitioner number 1 as a member was oppressive and unfairly prejudicial. C, declare that the present directors on the board of R1 company are disentitled from continuing in such capacity on account of their acts of oppression and unfair prejudice. D, declare the purported transfer of the 8% paid up share capital of R1 company to R3 from MSA as null and void. E, declare as null and void the resolution purported to have been passed in the EGM of R1 held on 4th June 2021 amending the Articles of Association of R1 company. F, declare that the articles of association of R1 company as they existed prior to 4 June 2021 continue to be valid and in effect. G, declare as null and void any act unfairly prejudicial to the interests of the petitioners undertaken by the respondents in relation to the affairs of the R1 company. H, direct the respondents to make good the losses caused and or disgorge any financial gains made on account of their acts of unfair prejudice and mismanagement relating to the affairs of R1 company. And I, pass any such other orders. Your Honor, we've also given the reasons at the end, but Your Honor, we'll seek to rely on our
188.
arguments note for that.
This is 188.
But this is a bullet points in contempt.
Company petition number.
Yours is CP 35.
Please, Your Honor.
Not
35. बाकी कहाँ है? बाकी CP.
No, not registered.
CP 188.
Which one is that you are relying on, Mr. Nagesh? Because I am not able to follow what she said. Your compilation is this common joint one. isn't
Yes,
it?
yes.
Of
Your
documents.
Can we go into?
Yes, yes,
look
Your
into
Lordship, we
that?
can go through that. In fact, Lordship, the main issue in this matter is, Lordship, is this.
No, this that one I have.
An auction purchaser of the shares of a foreign company, which is a shareholder in an Indian company, can it claim registration of the shares in the Indian company without following the procedure as laid down under the French court, which has allowed the transfer, the auction? Lordship, in violation of the articles of association of the company, can the other shareholder say, I have purchased the shares in auction and therefore I have a right to be entered into the register of members of the company, dehors the conditions stipulated in the memorandum and articles of association, dehors the conditions stipulated in the joint venture agreement? That's the
No, there
short
are
question.
two aspects of the matter.
Yes, Your Lord.
The first one is there is a condition imposed by the French court. That is issue number one.
Correct.
The other one is a condition that is part and parcel of the articles of association of the company.
Grateful, Lord.
So there are two aspects of this case.
Absolutely.
Now we will deal with the French
Yes.
component of the order. We'll
Correct.
go to that. But
Yes.
before that, we wanted to know what was the relief that is sought for by this company because of prayers. Because she's
yes.
saying something which we
Prayers-
don't know. That is not there.
Certified.
That is not in the convenience compilation of in the contempt petition.
Your Lordship,
Contempt is a subsequent
that's
event.
a subsequent event, Your Lordship. I'm not
So we will
dealing with
not
that for a
bother on that
moment.
because she is referring to volume 2 of contempt.
No, Your Honor, I was referring to the convenience compilation volume.
Madam, that we should be going through the CP only. Madam,
Your Honor, I can read it from the CP. I have no issues. Your Honor, the
convenience compilation is very abbreviated, the memo parties is not there, so there are
it's
many
there,
issues.
Your Honor. We reproduced it for the convenience of the time. But Your Honor may refer to page 88 of CP 35. That's where my final release are mentioned.
In this page number.
Sir, here she's saying page 88, sir. This will have the final reliefs and the entry reliefs, and the memo parties will also have to be received. That is at page
35?
6, sir.
But this has nothing to do with the transfer, no? Talking about only 8%. But that 47% government.
Where is the prayer for registration of the shares?
Sir, on page 86, entry relief. C part.
Okay.
Interim release.
Yes, sir. Direct response to rectify the restaurant member of the responsible party. So as to reflect petitioner number 1 and number of 6 lakh.
Relief number?
C, sir.
Lordship may have that interim reliefs at page 86, where they have culled out. Actually, they should have been the final reliefs.
It is, Your Honor.
Yes.
Final relief B says, Your Honor may confirm my interim relief prayers.
C, yeah, therefore, C is the main relief, Your Lordship. Direct the respondents to rectify the register of members of the respondent number 1 in a time-bound manner so as to reflect petition number 1 as the owner of 6,18,050 shares amounting to 47% of the paid-up share capital of the respondent number 1 company. In fact, this prayer is under section 58(1), Your Lordship, because
Where is that provision? That's what I wanted.
this relief is section 58(1). If the registration of shares is not happening in a company, they have the liberty to come under section 58, 58 and 59.
You get up.
59, Your Lordship.
Provision of law.
Yes, sir.
Lordship will kindly have 59. If the name of any person is without sufficient cause entered in the register of members of a company, or after having been entered in the register is without sufficient cause omitted therefrom, or if a default is made or unnecessary delay takes place in entering in the register, the fact of any person having become or ceased to be a member, the person aggrieved or any member of the company or the company may appeal in such form as may be prescribed to the tribunal or to a competent court outside India, specified by the central government by notification in respect of foreign members of debenture residing in India for rectification of the register of members. Here the case of the petitioner is that we have purchased the shares, we are asking the Indian company to register the transfer, they are not doing it, so they come under section 241 also. Though the Lordship is aware, under section 241 you have to be first a member of the company. They are not a member of the company so far. So I think it's a composite petition under 241 and 58. So usually people file a composite petition under 240 and 58. So the relief under 58 should be granted first by Your Lordship before Your Lordship takes up the other issues relating to operation mismanagement.
That's why I wanted to
Yes.
to read the prayers. So other prayers can't be granted unless and until you become a member of the company. So that's the point. So what is the other provision of the Companies Act in relation to registration of shares?
58.
Other 58.
Just one page.
Yes, just about that, 58.
So first 58 should happen.
Yes. If a private company limited by shares refuses, whether in pursuance of any power of the company under its articles or otherwise, to register the transfer or the transmission by operation of law of the right to any securities or interest of a member in the company, it shall within a period of 30 days from the date on which the instrument of transfer or the intimation of such transmission as the case may be was delivered to the company, send notice of the refusal to the transferor and the transferee or to the person giving intimation of such transmission as the case may be, giving reasons for such refusal. Without prejudice to subsection 1, securities or other interests of any member of public company shall be freely transferable, Lordship, provided that any contract or arrangement between two or more persons in respect of transfer of security shall be enforceable as a contract. This is important, Your Lordship. There is a joint venture agreement between the parties. The joint venture agreement says that if any shareholder intends to transfer the shares, he has to first satisfy all the conditions precedent. That is, the transferee should also abide by the conditions of the joint venture. He should give a non-compete undertaking. And that is for limited area. In our joint venture agreement, it is for Bhutan and India, Bhutan and Sri Lanka for a period of
5 years to the shareholders.
5 years for the
For
yes.
Macromedia, it is
Great.
still the company continues.
Grateful, Your Lordship. Absolutely. That's the position.
But what about
Indian
the,
company.
What about the Macromedia say?
Macromedia say
For them, the
as long as they are
non-compete
shareholder of the Indian
it will
company,
happen.
they cannot compete in other. Lordship may kindly note, even before entering into this joint venture agreement, we recognize the mutually saying that yes, both of us are in similar business, we should not compete against each other. That was the understanding. I will read those recitals in the joint venture agreement. Before we enter into this joint venture agreement, Macromedia SA was conscious of the fact, yes, I am also in the similar line of business. I don't want to compete with Indian company because I am myself a shareholder in the company. So therefore, this joint venture non-compete was given. And the memorandum.
Are you reading the proviso to read your joint venture? Because that any contract or arrangement between two or more persons in respect of transfer of security shall be enforceable as a contract. This
Yes,
is
yes.
No, that is simpliciter for transfer of shares.
Lordship, I'm saying,
And
Which
don't
your
read
honor
it
has to-
in terms of your JVA. That proviso should be read that in suppose in relation to transfer of shares, there is a contract between parties that should be upheld as valid. Say
Correct,
for example, that you have made a lien on the shares on a condition. So that should be taken as paramount for the purpose of reading this proviso that any contract or arrangement between two or more persons in respect of transfer of security.
Correct.
Two other shareholders or members or directors, say in case there is a sale, you have to sell it to me first for some preemptive right. So that will be provided by the proviso, not your JVA.
yes.
Don't read,
No,
that's
no,
a wrong
may-
reading.
may-
of
No, no,
it.
it maybe yes, Lordship. I stand corrected, yes.
The transferee may appeal to the tribunal against refusal within period of 30 days. Now I want to know whether 58 has been invoked in this petition.
Your Honor, before we come to 58.
I am asking a question, please answer that. There is a request, there is a refusal. Have you invoked section 58 in your petition?
Your Honor, my petition is under 59, 241, 242 and 243.
Let's see whether
Yes.
that they have
Your
asked
Honor,
for
may
that.
have my
Lordship?
petition at
Is
page
there
20.
petition filed under 58 or 241, 242?
So it is under 59.
59,
241.
read with 241, correct?
What is 59?
First page.
59 was the.
Lordship will kindly have the first page under section 59, 241, 242, 244.
Yes, Your Honor.
But rectification of a register comes post the, or then there's a difference between 58 and 59.
Lordship, 59 only talks about rectification of the register of either omitting or what we say that deleting or incorrectly adding the name. That is rectification.
Your Honor, if I may read
58
51.
is refusal of registration. 58, your Lordship may kindly see refusal of registration and appeal against refusal.
No, but actually in this case there was a refusal to register, correct?
Please, Your
Yes,
Honor.
yes. In my case, there is a. So
You
therefore,
sent-
strictly
you sent them a
speaking,
letter?
Lordship.
Did you send them a letter? As
No,
per
even,
section 58.
no, there is no letter, or they are not even responding to the request. So that is what Mr. Makkar was saying.
So that is also covered, but look at 59.
Lordship,
59
there is
was
no
also-
original document of transfer in the sense that.
How
they
bad
have
is
to have a
the
transfer
rains?
deed, the transfer deed, the
How
sales
bad is the
certificate, all
rains,
that were
I
not
say?
there, no?
Lord, the rains are not so bad except that there is a traffic snarl due to water loss.
Okay. We are on the issue of the relief which you have sought for in your applications.
Yes.
So we are discussing on that. So what was the tenor of your prayer and claim?
Your Lordship had asked me to circulate.
Because
this
primarily you were asking for that I should be allowed to
That's right.
register my shares in the Indian company. That was the main stay of your argument. I think it continues to be the same.
Yes.
But then that prayer comes as an interim relief.
Bharat.
So,
Even as the final.
that's, I
Even
saw
as the final.
B,
Yes.
clause B, which she
Yes.
said. So, unless and until you become a member of the company, the other reliefs of 241, 240 does not arise.
So we relied on those judgments at 241, 241.
I'm sorry, Lord.
Unless and until you become a member
That's
of the
right.
company.
That's right. And Lord, our case also is that entitlement to this 47% shareholding makes me entitled to maintain this petition. Because one of the objections taken by them was that you can't maintain this petition till the time you become a member. This is not a petition by a member. So we had, my Lord, given your Lordship two judgments to show that as long as I have a lawful entitlement to be
Acha,
registered as
sure.
a shareholder, I can maintain a petition for operation and mismanagement.
Okay.
And the operation we are claiming now, my Lord, is that they are causing a systematic death of this company by having transferred their entire shareholding and hiving off their
That's
business
okay.
to GE.
That is okay. That is
Your
it.
Lordship sees my note, my Lord, I have articulated these 4 points.
Where is the
Lordship
note?
had asked me to circulate these 3 notes, my Lord. During the vacation, I got a message that I must circulate, my Lord, a brief list of dates.
Courtmaster.
Yes. I have filed
Don't
it.
smile. Where is it? He's saying he's circulating.
I have filed it. I'll give another copy. Yes. Lord, may I have this copy? So, Lord, we have given a very short, brief list of dates, as also a note of arguments.
You've given the note of arguments right now. Do you want us to give
This one?
Huh?
Yes, we're good.
Yes. But this is the brief note of arguments, if your Lordship kindly sees. List of dates, your Lordship has already marked one earlier. This one is pretty much similar to that, except that it's shorter. So, my Lord, the 4 questions that your Lordship is called upon to decide in this case is,
Coming
first
now,
paragraph, if your Lordship sees.
You said
It's
it
been
is
filed,
okay.
Kishore, right? It's been filed?
Yes.
Yes. And word copy was given to Mrs.
We got it just now. Huh? That's
We got
okay.
it just now.
My Lord,
Yeah.
the word file was also handed over, my Lord, and it's been filed also. Anyways, my Lord, I'll just read. My Lord, it's basically a summation of what I have already argued. If your Lordship kindly sees, by way of the present batch of petitions, the following issues are before this honourable tribunal. Whether the actions taken by respondents 2 to payment of respondent number 1 company and Flowell are liable to be set aside on account of operation and mismanagement. Whether it is incumbent upon the respondents to acknowledge the petitioners as shareholders of respondent number 1 company, basis the purchase of shares by the petitioners from the liquidator of MSA. That is the most crucial question, my Lord. Whether the alleged contemners in contempt petition number 5 are in contempt of the orders of this court, orders of this honourable tribunal dated 10th March 2022. Lordship will recollect when I filed this first petition, filed this petition 35.
Yes, we know that, but contempt can be dealt with separately. There
Yes,
is no issue
contempt
on
can
that.
be dealt with separately. Now, my Lord, the only question would be, when your Lordship deals with the
D.
contempt, we are also praying for, besides punishment for contempt, my Lord, we are also praying for, my Lord, reversal of the actions which are contempt. That is the transfer of shares and restoration of status quo ante. Because today, in the teeth of the order passed by this honourable tribunal, they have hived off their entire shareholding. Today, my learned friend, whoever he represents, my Lord, he does not own a single share in respondent number 1 company. All 3 promoters have sold their entire 51.69% shareholding to this new company, GE Energy. In absolute violation of the order passed by your Lordship on 10th of March. Now, 4th is, my Lord, whether the joint venture and share purchase agreement entered into between Macamidi SA, that is the, my Lord, the foreign company, HPP Energy, and 3 of the promoters of MHPP, now who are no longer promoters because erstwhile promoters, because they have hived off their shareholding, automatically disqualified Flowell Hydro Technologies Private Limited from entering MHPP as a shareholder. Because there is that non-compete clause. Now, my Lord, I have actually summarized here what I have already argued. If your Lordship wants, my Lord, I'll
No.
just give these bullet points. This is exactly what I have already argued. And I have given the relevant page numbers, cross-reference the documents we are relying on from the convenience volume.
You have the earlier chart that we had given.
List of dates.
Oh, we have a hard copy here. I know, but we have this copy.
on number 3.
Mr. Amarjit, hold on there.
No, sir, is Jean Lon Zekri.
On the last page, the Lordship will also see the recommendation document of the liquidator in the order passed in the appeal, where the objections that are being taken by Mr.
That is there.
Nagesh
That is there in this
today.
volume. I'm
Yes,
correct.
sir.
We've also circulated a note of summary of primary allegations.
This one.
Yes, summary of primary allegations, questions of fact.
List of dates and events, sequence of events.
One more document.
Unfortunately, in the course of your argument, you had given so many papers. Let's see.
Therefore,
One minute.
Lordship may only rely on the last submission that I am making. This is
That's okay.
crystallized summary of whatever I have argued. As far as I am concerned, this is my final submission. Lordship is right, over a period of time, we have circulated 2-3 sets of list of dates and response to each other's list of dates.
But your list of dates which you are saying, which you gave during the vacation, that is not before us.
It has been filed. It has been filed, one copy has been given, I give another copy.
This is Mr. Nagesh's.
This is pretty much similar to what I have already filed, but the Lordship may take it now. This is again been placed on record. Word copy has also been given, I'll give another copy. There is not much change in the list of dates, except that this note of
Should put
submission,
a date.
we have tried to make it short and try
When
to
you take
articulate
it, you
all the
should put
points
that
that we
date.
have
I
argued.
can't be teaching all this. 7/7, you should put that date. What is this? Who has given this?
Sir, this is, so Mr. Nagesh has given his arguments and his list of dates and events, that is.
Today.
He says, he's given earlier also. Mr. Makkar has also given his arguments and his list of dates. This is Mr. Makkar's list of dates.
During vacation, I was instructed that I must file a written note of
Yes,
submissions
yes.
in this
We did
matter,
say
as
that.
also a brief list of dates. So I have re-articulated that and submitted it.
This is this one.
Yes, Lord. This one and this
And
list of
this
dates.
other one, which is.
Both, Lord.
Both are his.
Which
I was
one?
asked
This
to
one.
submit
This
both.
is
so I-
his list of dates and his argument. And below, those two are Mr. Nagesh.
Yes.
We thought, Your Lordship, that whatever we have filed, we should give a Word document, not the fresh document, which my learned friend has given today. No doubt, I mean, he is articulating his point. No. Whatever you are articulating is a
Yes.
part of the list of dates. But then Your Lordship recollects, finally Your Lordship asked, just before the onset of the summer vacation, Your Lordship said that I would like to see 3 documents: the bid document, the first court, the commercial court's order, the appellate court's order, the memorandum articles of association of the company. That will virtually decide, Your Lordship, whether the refusal of transfer is correct or not. That's all, Your Lordship, for the
That
limited.
Your Lordship had gone through on
But
the
then-
last day
No,
of hearing.
that's what I'm saying. If Your Lordship can, if we can go through those 4 documents once again, then.
No, there is no
Yeah.
issue on
Yeah.
that. We'll go
Lordship
through
will go
that.
through that.
But the point is this: Mr. Makkar was only harping on transfer of shares,
That's right.
and the madam who was representing Zekri,
Yes.
she delivered the shares. Are we correct? And
Share
it is
certificates
our
are now in the custody of the
concern.
court.
So some of the praise may not be relevant now.
Yes.
It has been transmitted to India and it is in our custody. But the point is whether the other reliefs, which there are multiple reliefs which is sought for, and what are your reliefs which you are seeking in your CP?
Transmission, Your Lordship, cannot be. Your Lordship will kindly have my petition. I don't
Let
want
us see
to.
what
Yes.
what is the nature of your relief that you are seeking.
This is, the Lordship has this company petition number 188 of 2021. Page 59 is the release.
So CP 180.
Page.
Page 59. So, the first prayer, Your Lordship, pass appropriate order, directions so-and-so to bring to an end to the first attack operation perpetrated by the liquidator of respondent number 2 for necessary orders and reliefs in respect thereto, including as per, Your Lordship. This stems out of the conditions imposed by the French court order, Your Lordship, saying that in violation of the French court order, liquidator could not have given that MGT5, transferred the shares to the auction purchaser. So therefore, I am saying that this is not correct, and therefore I am seeking the relief. Your Lordship will kindly see next relief. Declare as null and void the form MGT4 and form MGT5 dated 12th October 2021, whereby the liquidator has perpetually transferred the beneficial interest over 47% shares of the company to the respondent number 5. Their own employee, Your Lordship may kindly see, their own employee has signed this MGT4 and MGT5.
Whose employee?
Flowell's employee.
Obviously, because they are holders of share.
No.
But the liquidator has to
Lordship
sign.
may, on behalf of the liquidator, this is Lordship may kindly see what has happened. On behalf of the liquidator, the employee of Flowell transfers the MGT5. We are saying that it is not the liquidator who has signed it. How can you get the right to sign this document on behalf of the liquidator? And when the liquidator in liquidation is somebody else, he should have signed. Therefore, we've been insisting that on that, Your Lordship, that there has to be a mutual agreement as per the first court order. The mutual agreement is between whom? The liquidator in his official capacity as liquidator and the transferee, that is Flowell. That document has not come so far. So what we are trying to say is that here is an employee of Flowell trying to say that I represent the liquidator, signing the MGT5 and MGT4 and saying that, listen, I am complying with the orders of 12th October of the liquidator, and therefore I am transferring the beneficial interest. So, Lordship, these details have to be gone into. Lordship, it's not a simple case where an auction purchaser straight away says that, listen, I purchased, liquidator has signed a document, he's handed over the share certificates, I am now asking the Indian company to transfer the shares. It's not that simple, Your Lordship. Somebody, an employee goes and masquerades as the liquidator. He says, no, I represent the liquidator. I'm signing all the documents. I've given the documents. I've given the share certificates. I deposited it here. Lordship, it can't happen like that. You're in principle, you're violating an order of the French court. French court categorically said that you cannot transfer it unless by a mutual agreement. And that mutual agreement happened in the case of other shares. Lordship may kindly see, Macamedi France.
No,
that I will explain. Oh, yes.
My learned friend took all these objections before the French court, the appeal court in France, and
No,
all
that's
those
all right.
objections have been dealt
No,
with.
they allowed. No, they allowed. Let's not make a wrong statement. I will read the appellate court order.
Yes.
This is another case. The mutual agreement has been signed in all the transfers, except this one. It is precisely for this reason, Your Lordship, I filed a document before Your Lordship saying that in the case of other shares, there was a mutual agreement.
Now,
Page
this
3.
petition was filed in January 22. The appeal before the Paris court was decided in October 22. All these objections were taken by my learned friend with the liquidator and with the appeal court in Paris.
This is 312.
Yes.
There is another case where the authorized liquidator to sell by mutual agreement.
Lord, each case is governed by a different order.
Order, yes.
My learned friend can't draw a parallel of somebody else's case decided by that court. All orders passed by a court are not similar.
Our case, Your Lordship, my learned friend should know, it's a common order passed in respect of Macamedi France holding shares in many companies, not only in the Indian company, other companies, and all of them said that it has to be by mutual agreement. You can't pick and choose saying that this company is not bound by that mutual agreement clause. I will show that. Lordship, both of us
My
will go.
learned friend show
Yes,
it was a common order.
I will show that it was by mutual agreement, and the appellate court has upheld that also. Lordship, what I'm saying, Your Lordship, let's go on what has been written in black and white. Let's not say something which is not there.
Yes,
I will
yes,
just go
that
to what
we
is
know.
mentioned in the document.
My Lord, in fact, if Your Lordship recollects, I read to Your Lordship the appeal court Paris order, which clearly stated transfer must take place
sir,
in
yes, sir.
compliance
One minute, I'm
with the
just trying to-
statutory clauses.
Appellate court.
We are locating that in this common pool of documents. Let's see.
It's there in CA 291.
My Lord, this is
Lordship,
this
it's
will
not
be
in that.
there in the
Huh.
convenience file. My Lord, that appeal court order is at page 291 in
Page 10 of 291.
page 10 of CA 291. Because that was, my Lord, after this convenience compilation
Correct.
had been given. So if Your Lordship sees that page 10 of CA 291, that is the appeal court's order. Just open this.
Adding to this, confirm the order, adding to this on the minutes.
Mr. Nagesh,
Your Lordship has 291.
which page of your common index convenience compilation has that French court, appellate court's order?
My Lord,
It doesn't have
my
it.
Lord.
It
That's
doesn't
what I
have-
said.
that's
That order came later, my Lord. So that order is at page 11 of CA 291. That order came in October 22, my Lord. By that time, this compilation, I think, had been given.
Yes.
So annexure 54, page 301
Yes.
is the declaration of the successful bidder in the French bankruptcy
Yes.
court. Is that correct?
Yes, yes, Lordship.
13th of September 21.
That's right.
The Lordship will kindly come to 303 of the same, where I am insisting on this line. 303, we authorize the liquidator to sell by mutual agreement to the company Flowell Hybrid Technologies Private Limited under Indian law with headquarters located at so and so in accordance with the offer filed office of so and so for a total price of so and so, not including costs and charges, the following equity shares held by Macamedi SA. So this is order specifically mentions that by mutual agreement, and then your Lordship will kindly have further the next recital. We state that the firm Flowell shall be personally responsible for any disputes relating to the transfer of these securities and the legal and material conditions for transfer of the Lordship may kindly note legal and material conditions for transfer of these securities in performance of this order. We state that the firm Flowell Hydro Technology shall be solely liable for the costs and expenses related to the transfer of these securities. We state that date, this is important, date to own and enforce the rights of the securities is set at the effective transfer of the said securities. So they have the rights and as a shareholder only on the effective date. The effective date is the date of transfer. The transfer, it has to happen by mutual agreement, which has not happened. Lordship, ultimately, who shares they're taking in by auction? They're purchasing the shares of Macamedi France in an auction in France.
The liquidator sells Macamedi India shares to Flowell.
That's right.
The liquidator share
The company
sells
liquidation.
Macamedi.
Actually, it is other way about. The liquidator is authorized to sell by the order of the French commercial court to
Your
sell
Lordship
the
is
shares
absolutely
of
right.
Macamedi India to Flowell.
That's right.
Yes, by
That's a
mutual
simple-
agreement.
But
Your Lordship
then
may kindly see.
the
By-
sale is already concluded.
No. With due respect, Your Lordship, the sale is not concluded.
Declaration
Not
of
by learned
success.
print, please, that it is by mutual agreement and there is no mutual agreement like the one in the other case. Assuming for a minute what he's saying is right. My Lord, if at all there is violation of that order, the remedy with him is to go to that court, not here.
I thought the mutual agreement would be between the liquidator and this company.
That's right,
Flowell.
liquidator and Flowell
No,
is
no.
not
Which
with
means
him.
Macamedi,
I didn't
Macamedi
say,
SA.
Lordship, I didn't say it has to be between the liquidator, Lordship may kindly note, and Flowell.
And the buyer.
I'm
Yes,
How's he-
liquidator
Lordship,
and
liq-
Flowell.
Lordship may kindly see, there has to be an agreement between the liquidator
Yes.
and Flowell, and that mutual agreement will set out the conditions. Listen, we are giving you the shares, provided. Lordship may, then
The sale letter itself will be the letter of
That's
it
agreement.
is
That's
not.
the agreement.
With due respect, Your Lordship, then I will take Lordship from the bid document then. Let's start with the bid document. That gives every indication to the purchaser. Let's be very clear. The bid document is the first document where the purchaser of the shares should acknowledge, yes, I am buying the shares with
My
these
Lord, in
conditions.
fact-
Let's see that.
My Lord, in fact, this issue is no
That's-
longer res integra because these grounds were taken in the appeal before the appeal court in Paris. And Your Lordship may kindly see what the Paris
Okay.
appeal court has said.
Let's see that
Kindly-
appellate court.
Kindly see that
My
in
learned friend
page
is-
11, page 11.
If they
Yes.
have been taken
Just
care of,
one
let's see
minute.
that.
Yes,
Yes,
it has
yes.
been taken care of.
Let-
Kindly see page 11 of IA 291. This is the appeal court order. I'll straight away take Your Lordship to, kindly see on top, in the name of people of France, Court of Appeal of Paris, poll so and so, order dated 6th October 2022. Just come to the operative part, my Lord, at page 15. Last 4 lines. For all these reasons, declare the appeal filed by companies Macamedi India and Macamedi Italia as admissible. That is, the appeal is maintainable. Confirm the order. That is, confirm the order passed by the first court. Adding to this, said that the transfer must take place in compliance with the statutory clauses of the company's Mecamidi HPP India Private Limited and Company Mecamidi Italia, and more generally the law applicable to these transfers. So what survives in the argument of my learned friend that there has to be a mutual agreement, this, that and the other? The court has taken care of his objections. It has to be as per the applicable law.
And also the order,
And
my
the
learned friend is not
statutory
forgetting the
clauses,
order.
that is the Articles of Association.
The order, he confirms the order of the single
Yes.
judge. So let's, Your Lordship may kindly see.
All
my-
these objections were taken before the appeal court
No,
brought
no,
and
no.
dealt with.
We can't.
Where is the principal court of?
Yes, Your Lordship will kindly have 303, which we are reading just now, the conditions. And the appellate court adds to those conditions. It's not that that condition set by the single judge has been set aside. He adds further conditions. Your Lordship will kindly have 303. We authorize the liquidator to sell by mutual agreement to the company Flowell, a company and Indian Act, so and so, with the offer filed in so and so, not including costs, charges, the following equity shares held by Mecamidi as a firm, the securities amounting to 47% of the capital of the firm so and so, for a price so and so. Then, we state that the firm Flowell Hydro so and so shall be personally responsible for any disputes relating to the transfer of these securities and the legal and material conditions. What you may kindly note every there, legal and material conditions for transfer of these securities in performance of this order. Then, Flowell Hydro shall be solely liable for the costs and expenses related to transfer of that cost. Then, we state that date to own and enforce the rights of the securities is set at effective date of this transfer of the said securities. So, therefore, Your Lordship, first of all, there are some legal and material conditions for transfer that has to be complied with. Then, the effective date of transfer will happen only when the transfer take place.
The effective date of transfer would happen the moment he pays the money.
No,
He has paid the money.
Lordship, it's an escrow. Lordship, may kindly note. Today, if
Not
my,
in escrow.
it
They
is,
paid full money.
They
It
paid
is
the
on
full money.
record.
Lordship, I am saying with all sense of responsibility, Your Lordship, my learned friend may correct it. This money is in an escrow, not handed over to the creditors of insolvency.
I have taken to the liquidator.
Lordship,
Whether
what
the
happens?
liquidator
Mr.
has
Nagesh,
handed over to the
how does-
creditor or
Because
not,
the
I am
transfer is
concerned.
not complete, that money is not, Your Lordship, it's like that. It's like a resolution applicant paying the money and the IRP
Subject
doesn't.
to approve the
It,
plan.
yes, that's correct. So therefore, Your Lordship, I'm saying, why would the liquidator keep it in escrow? He would have distributed to the creditors of the company by now. He has not done that. He's saying, yes, there are disputes in relation to the transfer. So therefore, I'm not transferring the money to the creditors. It is
You
still
mean-
there in escrow.
You mean this condition of sale is an escrow account?
Yes, money is deposited in escrow account.
No, Mr. Makka, please don't get let us be very clear. What was the reason to keep an escrow account when the sale is at arm's length?
Lordship, the bid document,
Assuming he keeps it in escrow
Yes.
account, how does it be of any material to the purchaser in a open
Lordship,
public
purchaser
auction?
has parted funds. I'm not on that.
That's the
No,
end
no,
of the
the-
story. Why
no,
should we
it's
break
not-
our heads whether
Lordship-
he keeps in escrow
No,
or
the
doesn't
reason why he
even-
kept it in escrow, I would just want to say, instead of giving effect to that purchase, is that he is waiting that there are certain conditions. I have to enter into mutual agreement with the purchaser. That has not happened. Once the mutual agreement happens, then I will release the money. Lordship, may kindly see what the liquidator is saying. I don't want to take any risk on my side. There is an element of cloud in this transfer. So therefore, first of all, I'll have to enter into agreement with Flowell, which I have not done. Once I enter into an agreement means I know that Flowell is complying with all the Indian laws. It is complying with the memorandum articles of association of the company. Then I will send, because he has done in a similar manner, which I filed subsequently, a mutual agreement, Your Lordship, where specifically it has been mentioned, yes, the conditions precedent of the Indian company will be followed.
Then why would you part with the original share?
No,
if
the
this is
origin-
a-
liquidator has not. This is precisely my grievance. The liquidator has not. Who has given the shares to Your Lordship? John. The director of the French company, Lordship may kindly see, the director of the French company, Jean Chikri, who was also director of the Indian company.
Correct.
Since he represents the foreign company in Indian company, he held the shares. He did not hand over the shares to the liquidator. He deposits it here. That is a grievance. Ideally, what would have happened, Your Lordship? And therefore, in other cases, what happened where whenever John Sikri did not hand over the certificates, they applied for a duplicate certificates in case of other companies. So the duplicate share certificates was given by us, provided they give the indemnity and all those conditions precedent. So they've given that. In this case, they've been saying we do not have the share certificate liquidator. When suddenly your lordships and these proceedings were going, and one fine day John Sikri comes and deposits the shares, not through the liquidator.
Why money is not being released? Italy was
And Italy was reversed. One more fact. One more fact.
No.
There is no impediment to
On
transfer of these shares.
the deposit of shares, was that
Lord,
madam
on the
who,
deposit of shares, the liquidator remained under the impression that the shares were lost, and therefore he wrote to the company to issue duplicate shares. Later on, Mr. Zekri disclosed that those share certificates were in fact lying with Mr. Zekri, and therefore we moved an application. Your lordship directed Mr. Zekri to deposit the shares here.
That's true.
Liquidator has written to the
They
company
did
to
not.
issue
You
duplicate
wanted
shares,
it.
saying that the shares are
You
lost.
wanted it.
No, my question is,
Yes.
as the madam who represented Mr. Zekri, the
Please, madam.
French,
I think she's online.
She's online, sir.
I'm online. I'm online. I apologize.
that's, see,
Yes.
did she inform the liquidator that she has handed over the?
Yes.
Have you informed the liquidator, madam?
My lord, I handed it over through the honourable court, through your lordships. So the liquidator is being represented through their authorized representative, and
No,
since
my
so
question
they're
was,
fully aware.
have you informed the liquidator that you have handed over the shares to this tribunal?
My lord, the liquidator is represented through
The
me.
liquidators
Liquidators are authorized Mr. Saroj
That's
to
right.
appear in this court. So Mr.
He-
Saroj
I had
my lord,
served.
represents the liquidator. The Indian representative of liquidator is Mr. Saroj, because they paid the entire sale consideration. Your lordship will also
I am asking only one question, because to complete the circle of events, the fact that the shares were not lost or not available, and therefore a request was made for issuance of duplicate shares. Now that the original shares have come back and delivered by Mr. Zekri through the council, was it informed to the liquidator? Yes, the original shares have come. It is now with its tribunal. Has it been informed to the liquidator? That's the only thing. She
not
has.
to the liquidator probably, Lord. I don't know my lord.
I've informed through its representative, my lord.
Have you by email or any?
By email, I don't have a direct communication with the liquidator, but because the liquidator is represented through Mr. Sorot, therefore I had served him a copy, of course.
Lord, your lordship
So
will
he's
also
fully aware.
recollect on the last date of hearing, a crucial document your lordship has gone through, my lord. That was the recommendation document by the liquidator to the French court. Because, my lord, there has been an attempt on part of my learned friend, because they also participated in the same bidding process through another company. So there has been an attempt to torpedo this transaction right from day one. So in that, my lord, they had written to the liquidator that on account of this, my lord, non-compete document that JVSPA, my lord, this transaction cannot go through. They had taken these objections. They made a detailed representation to the liquidator that even despite being the highest bidder, why these shares could not be sold to us. Liquidator took an opinion from a legal firm there and a law firm in India. Basis that opinion, my lord, he made a detailed recommendation that there was no impediment to transfer of these shares, and if there is a non-compete clause in that JSPA that is subsequent to transfer being registered, that can't be enforced or, my lord, used to block this transfer. And that recommendation document, my lord, was submitted to the Paris court. It is part of the record in that convenience file. Your lordship had gone through that document in detail, my lord. This is annexure 40 at page 233.
And that was also upheld by the Court of Appeal?
That's right. That's right. That was factored in by the first court, upheld by the appellate court.
The issue liquidator of the state and
Bid document पर रखा ना?
who is doing this? Liquidator. I'm sorry.
Liquidator of this, the committee has said.
Let's see. Did the name change? Liquidator's name, Anton Barty. Was it the original liquidator? I think his name was different.
Who's the liquidator?
Yeah.
Because I find this name is different.
Mr.
And
My Lord,
so-
Mr.
Yes, Your
Sarot,
Lordship.
who represents the liquidator and who holds the power of attorney on behalf of the liquidator, is present. He says, I have already informed the liquidator. He says, all these
No, no,
proceedings cease before.
I am.
Yes.
There's a change in the name of the liquidator because Anton
Is there?
Barty.
Yes. Yes, Antoine
I
Barty.
remember the first
Antoine
liquidator name
Barty.
was different.
Stefan Gorias. Your
Stefan.
Lordship is
Correct.
right. Yes, yes. Your Lordship is right.
Authorization.
Lordship, Your Lordship, before one more important point relating to the escrow, I think I should bring to Your Lordship's kind attention, which Your Lordship is asking me. There are two things, Your Lordship. One is declaring a person as a successful bidder. The second one is acknowledging him as the holder of the shares pursuant to the successful auction. Now, Your Lordship, one important point, 3, which Your Lordship, because that mutual agreement, this I think as a fact I should bring it to Your Lordship's notice. 303, Your Lordship has that. We acknowledge we authorize the liquidators to sell by mutual agreement. Your Lordship has that line.
Yes, sir.
Lordship will kindly have the 2 bullet points. Why I am saying that mutual agreement is important is the securities accounting to for 40% of the firm Mecamedi HPB India Private Limited for a price of 441. That's one. Second one, Your Lordship, is important. The securities accounting for 45% of the capital of the firm Mecamedi Italia Sri for a price of so and so, so and so. Since they did not sign the agreement, Your Lordship, in the second one, Italia, as I was indicating, there has to be mutual agreement. This amount which Flowell paid for acquiring this 45% of Mecamedi Italia was returned. It was lying in escrow. It was returned to them because of the non-signing of that mutual agreement. This is precisely my grievance. Therefore, I am
Quite
saying,
true. In that case where the Italian company Media was supposed to be sold, if the condition is not complied with, it is right for the liquidator.
same
not-
conditions, a lot. Same
No,
conditions.
no. Then he could have declined. As in the case of Italia, the liquidator could have declined to sign this,
No,
saying that transfer and confirm the sale.
Lordship, all conditions.
What
are
is the
same.
date of confirmation of sale, Mr. Makkar?
Same order for both. Lordship, may kindly see same order for both.
Successful bidder.
13th September 2021.
Yes, 301.
Yes.
So, in this case, now my learned brother was pointing out that document of the subsequent, the new liquidator, who confirms that he have received and transferred.
Yes,
Lordship, may
You see
read
this
that.
annexure 76, because you are giving separate volumes. This is a confusion. This is the
Lordship,
new liquidator.
who's writing this
Mr.
letter?
Bharti.
Who's writing that?
Mr. Bharti.
Yes, that's correct. I'm saying, Your Lordship.
The new
He's saying
liquidator.
this is all happened subsequent to Sarod saying that I represent the
But
liquidator.
it is not by
is
Sarod,
page-
it is by Mr. Bharti.
Your Lordship is reading that page. Just show
Annexure
me.
76390. From
390.
to
Let me read that, Your
liquidator
Lordship.
so-and-so to hydro technology.
Yeah, no?
Yeah.
Yes, Your Lordship, may kindly see. Your Lordship will kindly see. Anthony Barty, liquidator of Mecamedi SA. Your Lordship is saying 391.
Read the last paragraph.
Yes, Your Lordship may kindly see. I, the judicial liquidator of Mecamedi State, and confirm Flowen as duly paid full consideration. No, Lordship, here what they're doing, they're declaring your Flowell as the successful auction purchaser. That's all. And abandoned shares in the name of Mecamedi in your company pursuant to the approved order dated 13 September 2021. According all the rights and financial interests in respect of the above mentioned shares shall vest with Flowell with effect from 13 September 2000 pursuant to the approval order. So what are they saying? Lordship may kindly see, there are two different aspects. Declaring somebody as a successful bidder and saying that you get all the rights as a shareholder is only when there are certain conditions to be fulfilled both under the Indian law and under the agreement signed between
In
the
fact,
shareholders.
What your argument that it was declined in respect of Italian company?
Yes, I will show that document.
No, but then this speaks otherwise because
No,
Lord,
not
in
in
fact,
this.
may I point
Not
out
in
one?
this case. This is
More than
Flowell.
390. Lord, 390, Your Lordship is reading that is addressed by SA Mecamedi through the liquidator to Flowell. Kindly don't read this. Read the document that has been addressed to them by the liquidator, which is at 387.
Never sent to us.
Just 3 pages above this. That is addressed by the liquidator to board of director on the same date. 2 letters are written, one to Flowell,
I showed
one
you,
to
didn't
them.
get it.
So kindly see what do they tell them. liquidator tells the board of directors of Macamidi, subject written consent regarding transmission of 47% of shareholding of SA Macamidi in Macamidi HPP India Private Limited to Flowell. Kindly come to the last two paragraphs. As such, the board of directors, para 2 on the next page, my lord. As such, the board of directors of MHPPIL is duty bound under law and equity to acknowledge the sale of clean shares, transmit the clean shares in favor of Flowell, and accordingly amend the register of members of MHPPIL and perform all requisite mandatory formalities for completion of such transmission pursuant to applicable provisions of Indian law and constitutional documents of MHPPIL, including its memorandum and articles of association. Pursuant to approval order, MHPPIL is also required to duly recognize and not to interfere in Flowell's rights and privileges in respect of clean shares. Now, my lord, what could be clearer than this?
Lordship, that letter we have not received.
This is absolutely extraordinary, my lord.
No, okay. If you think that I've given
this
a good
is a common convenience compilation filed by us.
Lordship,
today,
Lordship,
at the end of argument, they say I haven't received
Lordship,
this.
today we are in a court. We'll have to come clean to your Lordship. I'm saying with sense of responsibility, Lordship will kindly come to page 397. Lordship, many things are read. Okay, there is a letter. I'm saying that where is that letter to us? 397. Lordship will kindly have page 397. 397. Lordship may kindly have 397. Lordship may kindly see the catch here. This letter doesn't come to me, and when I ask them a specific question, where are the letters, what do they say? Lordship may kindly see the original copies of the above mentioned letters of 14 December 2021, which my learned friend just now read. I complained on page 397 that I have not received those letters. Lordship will kindly have page 397, para second. At the outset and without prejudice of position, it is to inform you that we have not yet received the two letters dated 14 December from the liquidator, Mr. Anthony Barkey, because that letter your Lordship just now read. Now, Lordship may kindly see what is the response at page 399. Their response at 399, para 3, to the bottom of the page. The original copies of the above mentioned letters dated 14th December 2021 addressed to you by the liquidator are presently with us. Lordship may kindly see a document which is supposed to be sent to me, the original letter is sent by the liquidator to them. And let me continue. I will read para 2 also.
Yes,
let me read. It is presently with us at our office at the address given below. You may send an authorized representative with an appropriate letter authority to collect the same at the earliest to avoid any further delays. This is their statement in black and white in para 3. My learned friend wants to read para 2. Let me read para 2 also.
Yes.
We are surprised to know that your letter dated 4th January 2022 mentioned in reference 1 above, you have deliberately failed to acknowledge the receipt of duly notarized and apostilled copies of the above mentioned letters that were sent to you along with a previous letter dated so-and-so dated 29, referenced in 1 above. A copy of the said letter with its attachment are enclosed again for ease of reference. Having said that, when it comes to 14 December 2021, they say that the original is the liquidator sent to me. So they are not answering that this 14 December has been sent to you. Why would a liquidator send it to Flowell, your Lordship, this letter? If it has to be addressed to me,
letters are dispatched, one to me, one
10
to them.
emails to me, 10 emails to me,
And
this letter doesn't come.
What is dispatched to him is copies endorsed to me.
No.
Therefore, the original is with me.
I'll show the emails.
Okay, Mr. Nagesh, but finally, did your client send a man to him to collect the letters? Yes.
No, we said that Lordship may kindly see, we are not recognizing this company. Lordship may kindly note.
That's the problem.
Flowell, where does Flowell come? We said that you have to comply with the order, French court order, appellate court order, conditions of the, and let me read your Lordship. I'm not saying away. Lordship, even on that day I said that let them give the non-compete undertaking. I will register the transfer today. Your Lordship, see my bona fides. Lordship may kindly note my bona fides. I never refuse to transfer the shares.
That is the only issue.
Yes, that's the only issue. And that issue emanates from the memorandum articles, the joint venture agreement and the French court order recognizing that conditions. I'll read those again. Lordship may kindly note, I am not against the transfer of the shares. Let them give the non-compete offer.
articles, it is a condition precedent.
There is a shareholder.
Condition subsequent.
Lordship may kindly see the
Where-
articles.
Where are the articles?
Yeah,
of-
page, the same, 56,
No objection
56.
in making that statement that we
22.
will be fully compliant with the articles of association, not with JVS.
Lordship may
JVSP
kindly
doesn't
see.
bind me.
That is easy to say. Lordship may kindly read page
Once I become a
56.
shareholder, I am not a party to any JVSPA that was privately entered into amongst other shareholder groups. I will be fully compliant with the articles of association. On that
Obviously.
ground,
As
my
a
lord-
successor.
Yes.
As a successor, he should
Obviously,
be.
any
Absolutely.
shareholder is bound by the
Lordship
articles.
is absolutely right.
Simple.
Yes.
There is no.
As a successor.
This is how on this premise we wanted to take the issue forward in respect of this interim relief which was sought for is there. Subsequently, whether the JV will hold good or not is an issue which
That
has
will
to
be
be thrashed
debated
out
in an
later.
appropriate court, my lord.
Lordship will have to decide. I am saying it is a condition precedent. My learned friend is saying it's a condition subsequent. Lordship will take a call on that. So therefore, I am saying Lordship will kindly have page 56 of the Articles of Association in the convenience compilation, where it is clearly said it is a condition precedent.
Why not 2015? Just when
Any version,
when
Lordship may kindly say.
MSTP was
Lordship
was
may
made.
read any version. I have no problem. 2015, yes, Your Lord.
Okay, and shareholders and that JVS SHA? Which
Yes,
page?
JVSHA, Your Lordship will kindly have, starts at page 2. And the Lordship may kind.
No, this thing, the non-compete clause.
Yes, I will read that.
Article 11?
Lordship will kindly come to page 11, Article 8. Article 7, sorry.
Transfer and transmission of shares.
Yes.
Huh.
Lordship may read that. Your Lordship is reading Articles 22 first? I think Lordship.
Articles, AOA.
Because.
We are reading 8, Article 8 of 2015. Because that was the first article which came.
No problem, Your Lordship. No problem.
My lord,
29.
This has,
Let me.
this JVSPA has never found its way to the articles.
Lordship, it is. Let's not make a wrong statement here. It has found. Let me read 29.
Then you should not worry. Then
No,
we are
I am
bound
worried.
by the articles.
No, I'm worried because you are saying that I will not enter into non-compete as a condition precedent. Lordship will kindly have 29. None of the shareholders, 8. Your Lordship asked me to read 8. Lordship may kindly have page 29.
None of the shareholders.
Yes. None of the shareholders shall sell, transfer, assign or pledge, encumber or otherwise in any.
42 of your.
Mr. Nagesh, please read
Lordship, my
page 200.
Honorable
page
technical member
43.
asked us to read articles of 2015. The one at page 56, 22 is the
That
latest
was
one.
That was of the company before this. So the company's name changed. So we are reading 215.
Your Lordship may
because
kindly
this is
read.
the current company.
No problem. Lordship can read both. I have no issue.
Three versions.
3 versions. I will read all the 3 versions. Lordship may bear with me. I will read all the 3
Come
versions.
to page 42. Paragraph.
Page?
Page 42, article AOA 8.
Yes. Page 42.
42.
Yes.
This is Media.
This is Macamity SPP India Private Limited. Of 2012, it was some other name.
Which
Yes,
year
yes.
is this?
So 2015.
They've changed the name, Your Lordship. Yes, Your Lordship will kindly have 8.
2015.
Page 42. Your Lordship may read. All the versions are identical. Your Lordship may kindly read this first. 8. Your Lordship wants me to read that? At
Yes,
page
please.
42?
Yes, please.
Yes. 8. None of the shareholders shall sell, transfer, assign or pledge, encumber or otherwise in any manner dispose of its share in the company to an affiliate or to a third party unless such affiliate or third party agrees to be bound by all rights, obligations and liabilities of the transferring party. All rights and obligations of the transferring party pertaining to the transferred shares, comma, including those defined in the memorandum and articles of association. So there is.
That he is conceding. There is
No,
issue.
no, he is not conceding that. This is precise.
That's
Lordship may kindly
no,
see.
You heard him say.
No, he
I
says
am
that-
bound by the articles of
Absolutely.
No, no,
There is
Absolutely.
no second thought about it.
Lordship-
He was very clear, sir.
Absolutely.
Don't get confused.
Lordship, if it is articles of association, my learned friend is saying, I am saying this clause not only reads about articles, there are other conditions of transfer. That is
Other
precisely
conditions of transfer I am not bound
this is
by
an-
because I am not a
How
party.
can it be? This article 22 says that anybody who is purchasing the shares is bound by the conditions of the transferring party, including, Lordship may kindly see, it's an inclusive definition. One is the conditions precedent, that is, all conditions, rights and obligations, liabilities of the transferring party pertaining to the transferred shares. Lordship may kindly note, where will you find all the conditions pertaining to the transferred shares? You will find it in the joint venture agreement. Then it adds one more thing. It says that, okay, apart from the conditions mentioned in the transferred shares, pertaining to the transferred shares, you will have to comply with those conditions mentioned in the memorandum articles of association also. These both are mutually exclusive. It's not that you simply say that, oh, I'll confirm to the Articles of Memorandum of Association. No, you will also have to confirm to the transferring parties conditions which are stipulated in the document which is pertaining to the transferred shares. So
My
therefore,
learned
I'm
friend is
submission.
making reference to
Let-
the Articles of Association, which in any event bind us. Whatever be the interpretation of this, my lord.
Exactly.
Today, my
It
learned
is
friend
comma-
can't, my lord,
it is
preempt
comma-
that and call upon your lordship to interpret it as of today.
Condition precedent.
This is a condition precedent because
No,
it's
no.
comma
No,
and
no.
including.
Yes.
See, on the earlier date of hearing, we were very clear on one aspect, that as a matter of right, a person who purchases a share, be it through the liquidator in France or anywhere, the transfer of shares cannot be made as a condition precedent that you have to sign this and that. It has to happen as a matter of law and
That's
by
right.
courts, by procedure prescribed. The event that follows the registration of share will be the rights and liabilities which comes on every shareholder will applicable to him. How that has to be interpreted is an issue which is
Subsequent.
post to the registration of these shares. in the
You
name
can't
of
block
the
my registration.
purchaser. That is the crucial way to look at it.
Lordship, grateful. 2 judgments I'll cite your Lordship. That's all. Then your Lordship will take a call precisely on this issue which your Lordship saying that the auction purchaser, you will have to transfer the shares. All that JV agreement will come subsequently. But you will have to transfer the shares because he's purchased the shares in auction. And he will be bound by the Memorandum Articles of Association. That's what your Lordship is saying. I'm saying, your Lordship, unless he confirms that he will comply with the conditions precedent under the joint venture and memorandum articles, as an auction purchaser also, you cannot say that as a matter of right, please transfer the shares without me complying with the conditions of transfer. That I will show 2 judgments, then I'm done, your Lordship.
Very well.
Yes.
And my lord, we are relying on that V.B. Rangaraj judgment.
The Bombay High
that
Court
unless a condition is incorporated in the
No,
articles.
has he quoted this judgment earlier?
No, it's not.
No, it is part of my Lordship, my note. Your Lordship may have them, don't. I've given that note. Tabular note. Your Lordship will kindly have.
Tabular.
Yes.
Where is the tabular?
See?
Summary precedent.
We have this one.
This one, yes. Tabular note.
Part of this.
It's a part of that.
Which page?
Your Lordship will kindly come to serial number 7. Is it in this? No, it's a part of that. Okay.
Serial number 10.
Serial number 10. Give me the judgment.
Manila Brijlal Shah.
Manila Brijlal Shah. Grateful, Your Lordship. This one.
You have the judgment?
Auction purchase. Your Lordship has that heading? Auction purchaser does not. Of course. No problem. Auction purchaser does not automatically become a. I'm just giving the judgment, Your Lordship.
No, the summary of primary allegations is given today. No?
No, Lordship, it was there. Given
Then
last
where was the
occasion.
judgment? Where is the judgment then, along with that?
Your Lordship, the copy of the judgment was not given. Your Lordship, I'm sorry. It was referred here, but not
Too
given.
smart, huh, you are.
No, Lordship, I'm sorry. The copy, he should have given the judgments along with that. Your Lordship would have read that. Yes, Your Lordship, correct.
Then why do we waste time looking at your notes? Because I didn't see this at all.
No, he extracted the page number. Ideally, he should have attached the judgments along with that. Yes.
So I'll put it as 7-7 only today.
Page number de dena. Judgment. Your Lordship has the judgment? Manila. Okay. Give me. I'll just read page 83, 84, Your Lordship, and 86. Lordship has 83, page 83. This one, it starts like this.
Internal page 4. Internal page 4, Lordship.
Lordship will kindly have internal page 4, which is mentioned on the top of the judgment. SEC online web edition, Your Lordship has that?
Page 3.
Then Lordship will kindly come to internal page 4, towards the bottom, page 83 is mentioned, Your Lordship.
Yes, sir.
Yeah, may I read that, Your Lordship? Yes. Now on the merits, the simple question involved is whether the appellant is entitled to claim that director shall register his transfer and is so entitled by reason of the fact that he is a purchaser at a court sale and not a private purchaser, like my learned friend's case. For admittedly, if he were a private purchaser, he would not be entitled to throw any such obligation upon the directors. It is urged that his position in this respect is substantially improved because he is a court purchaser. But after all the argument which we have heard from Mr. Thakur, I am unable to see in what respect his position is materially altered or improved by the circumstances that he purchased at a court sale. It may be that when the directors refuse to approve a transfer after a court sale in execution, they may ensure inconvenience in practice. But similar inconveniences will also ensue when private purchasers' transfer is refused to be accepted by the directors along with the limits of their discretion. For the purposes of this argument, we must of course assume that the directors would be within their powers in refusing to register present appellant if he were a private purchaser and not a court purchaser. Upon that assumption, I can see no reason why the director's powers should be curtailed merely because the appellant purchased at a court sale. For whether the sale is made by a private individual or by court, it seems to me clear that the thing sold and transferred from the seller to the buyer is merely the property in the share plus a limited, not an absolute right to have the transfer registered. But the appellant here contends and must contend that when he purchased from the court, he purchased over and above the share the absolute right of forcing the directors to register his name. But that is a right which ex hypothesi the court never had to sell. I infer that the appellant never bought it. The conclusion seems to be reinforced by the consideration to which the learned judge had referred, the consideration namely that upon the case for the appellant nothing would be easier than to override that part of the memorandum of association which invests the directors with the discretion to refuse the professed object with the discretion to refuse to admit undesirable candidates. For if the appellant is a right, then a person whose professed object might be to wreck or damage the company could nevertheless oust the director's discretion. He is my competitor, Your Lordship, admittedly, and compel them to register him by the simple process of purchasing through the court after a collusive decree. On these grounds, I am of the opinion that notwithstanding that the appellant's purchase was made through the court, the director's power under the memorandum of association of refusing to accept the appellant as a shareholder are unaffected. Upon this point, the learned district judge had held that the directors were justified in their refusal, and all that is necessary now to say upon this part of the case is that of the fact found no question in arises which would properly be urged under section 100 civil. It is clear from those facts that the directors would be justified in thinking as they did think that the appellant's object is obtruding himself upon this company was to impede, hamper, embarrass the business of the company, not to promote it. I think therefore that the appeal fails and should be dismissed with cause. So this is one judgment. Your Lordship will kindly have specifically, Your Lordship may kindly, I'm sorry, Lordship, one more page, the next page, specifically on this issue, very important. Next page, Your Lordship, page 86, Your Lordship has that? In the second paragraph, the issue in this case, Your Lordship has that? The issue in this case raises two questions, one of law and the other of fact. The question of law is whether the purchaser of certain shares of a limited company at a court sale in execution of a decree against the shareholder is entitled as a right to have the shares transferred by the company to his name. It is contended on behalf of the appellant that the company has no discretion in the matter and has no power to refuse to transfer the shares to the name of the auction purchaser. It is common ground that a private purchaser from a shareholder must submit his application for transfer to the company, and the application is liable to be dealt with by the directors as provided by Articles 22, 23 of the Articles of Association of the company in question. But it is argued that the auction purchaser, in virtue of his purchase at a court sale, has a much higher right in this respect than a private purchaser. On principle, I am quite unable to see how the purchaser at a court sale can have any higher right. He purchases the property subject to the same limitations to which the original owner could sell privately. The intervention of the court and the compulsory character of the sale cannot prejudice the rights of the company and cannot alter the position of the purchaser in any way on this point. There is nothing in the provisions of the Indian Companies Act and Code of Civil Procedure to support the argument that the company is deprived of its usual powers and relieved of its corresponding obligations to deal with the transfer application when the transfer is sought by virtue of a court sale.
Was there a similar provision of section 58, 59 in the 1913 Companies Act?
Yes.
Have you
111.
seen it?
Lordship, yes, I will show that. Lordship will kindly have the. I'll just check up a little because it is 1913 Act. because 1956 had 111.
But
I don't know the corresponding.
The Bombay High Court has not dealt with the provision of the Act.
No, it has, Your
It
Lordship.
is Article 22 and 23 of
Correct.
the Articles of Association of the Company.
Correct. It says so under. Lordship may kindly see. The
And-
Lordship will kindly have.
Whether there is similar article in the Articles of Association of this company.
Company.
No. Lordship
22
may
and
kindly-
23. I
Lordship
don't
section,
know.
it is 38, Your Lordship.
Fact specific.
Indian companies, no, fact specific is what? It is saying that whether you are an auction purchaser or a private purchaser, the conditions remain the same. You can't say that my rights are higher if I am an auction purchaser. That is what the judgment is. Then Your Lordship will kindly have the subsequent judgment also. So therefore, finally the finding in this judgment, Your Lordship, is I am therefore of the opinion that purchaser of a court sale is not entitled as a matter of right to have his name entered in the register of company as a shareholder. He is subject to the same rules on this point as a private purchaser in the judgment which I gave, Your Lordship. That's the Bombay High Court. Now, Your Lordship, I will have one more judgment, Your Lordship, on this. The bank which I have handed over. Give it to that side. That's the Bank of Hindustan Limited versus Kauta Suryanarayan, 1957, SEC Online, Madras, 90, page 731.
Now this we have to read very carefully. Justice Rajamanna's judgment.
Lordship, I see. Oh, Dedi. Lordship is saying something about Rajkumar, CJ and Panchab Iyer.
No.
Ah.
Justice Rajamanna was the Chief Justice.
No,
of
correct, Your
Madras
Lordship.
High
I
Court.
thought Your Lordship was throwing some light on about
No,
it.
no.
Ah.
These are supposed to be most landmark judgments of those days, which still continues even as of today. So let us see the ruling. Yes,
Lordship,
which
before Your Lordship asked me what is the relevant section, it is section 38 of the 1913 Act. Lordship may kindly note, section 38, power of court to rectify the register.
Section 38 of 1913.
13 Act, yes. And it is mentioned in the judgment. I should have shown Your Lordship, in fact, in the
Indian
judgment which I
Companies
read.
Act, Section 38.
38, it mentions, Your Lordship. Section.
Purchase of shares at court sale rectification. So 38 is commensurate with 59 rectification.
Yes, I'll read that. For Your Lordship, just 2 lines. If the name of any person is fraudulently or without sufficient cause entered in or omitted from the register of members, or default is made or unnecessary delay takes place in entering on the register the fact of any person having ceased to be a member, the person aggrieved or any member of the company may apply to the court for rectification of the register. Same. The court may either refuse the application or may order rectification of register and payment of the company of any damages by an aggrieved, and may make such order cause as its discretion. On any application under this section, the court may decide the question relating to the title of the person who is a party to the application to have his name entered in or omitted from the register of members. Question arises between the members and alleged, or between members as alleged members, of one hand, that the company on the other hand, and general may decide any question necessary expedient to
But
be
are
decided.
we on 59 actually?
Yes,
No,
the petition is under 59. That's what I'm saying.
58 is more appropriate, isn't it, for you, for registration?
59 also deals with the same thing, Lordship.
No, but 58 is for transmission of shares.
Yes.
Rectification comes.
Transfer. 58 is also for transfer and transmission, Your Lordship. Because if Your Lordship will kindly.
Refusal to register the transfer.
That's right.
So 59, he says that please rectify the register. My name is not being entered into the register of members. That's what.
Okay, you are.
Rightfully, I should have been.
That's what he said. And Your Lordship, to
Lordship
complete,
would
to
have 59.
complete this.
So both these judgments are of those days when the suits were allowed to be filed. Now, sir, after the CLB upon this, these suits, etc., are no longer allowed, sir. Now the Supreme Court don't have jurisdiction.
True, but the ruling is applicable, no? See. Yes.
Because Your Lordship, originally, all these company issues were going to the courts. It's only subsequently the tribunals were formed to hear the company matters, Your Lordship. All these company matters were going to the courts only. Till 200.
Yes,
we were. Yeah. The ratio remains the same. Your Lordship will kindly have 731 of this judgment. Sorry. Page 731, Your Lordship may kindly have that. Lordship has that? Yes, sir. Sixth line from the top. Lordship has the only possible exception. The sixth line from the top, Your Lordship. Understood?
So, which page number?
731. Sixth line, Your Lordship. The only possible exception is that when the company refuses to register a transfer out of spite or from corrupt and improper motives, a writ may possibly lie by the aggrieved person to enforce the registration, though we give no ruling on the point as it is not necessary in the facts of this case. The discretion given to the company under the Articles of Association is, in our opinion, perfectly justifiable. As that is necessary for the well-being of the companies and was the basis of the contract between the company and the shareholders. It is intended to prevent the company from being ruined by infiltrating fifth columnists, parading as transferees, or by transfers in the names of impecunious persons. First time I am hearing this word, impecunious persons by solvent people in order to get rid of their liability regarding unpaid calls, and also to prevent the cornering of all shares by wealthy people to the prejudice of the ordinary shareholders. Thus, people interested in a rival company carrying on the same trade might want to become transferees in respect of the bulk of a company's shares and to get their names registered in order to obstruct the work of the company and to facilitate the business of their own company. There are complaints filed against me. So all that, Your Lordship, I am saying that.
No, but
yes.
Maybe this ruling is there, but today's company law, can we say that? Because
yes.
No, I don't think so, because this principle may have hold good in those times. Presently, the law has changed in such a manner that it is a trading commodity. If it's a public listed company, there can be no fetters on purchase. The private limited company, can you say I will not sell? Because unless you can say, you have put a condition that without your consent, it should not be sold. That is already there. But when the shareholding company, French company, which held in Macamedy, India, went into liquidation, all the shares that it held in different companies were put on block. And in that case,
they also tried to buy it.
I'm saying, why are you pulling the words out of my mouth? I'm saying, you also went to France, participated in the proceedings. You wanted to buy those shares because it was an open sale.
That's right.
And between you, Flowell was the highest bidder and the bid got in their favor. So now to say that, suppose you had got you had been the higher purchaser of the value, then there is no issue.
No, I would have given that undertaking a lot. Non-compete undertaking I would have given. That's what I'm saying. I have given.
Where is the question of non-compete? You are buying your own shares.
Lordship.
You are buying your shares. There is no question of non-compete there.
Lordship.
But if it is a third party, you are saying non-compete should come.
I'm buying the shares of Macamedy France, Your Lordship, may kindly see. If I was the purchaser also, individuals. India Macamedy. No. I'm saying Macamedy France shares in Indian company. What I meant was that. Not that I was. Not the shares of Macamedy France.
I'm saying.
Yeah.
Where is the question of non-compete?
Your shares held by the French company was in public auction through the liquidator. Similarly, Macamedy France had shares in so many other companies in Italy,
Italia and others.
Portugal or some other across the world.
That's right.
So all those shares held by Macamedy SA France came in public domain, and each one was bidding on his best possible effort, and you also bid for your own shares because you wanted to safeguard your interest. Now the question is, when a third party buys that, he is asking only for transmission of shares in his favor. Now your point is, unless you give me the non-compete clause, I will not allow you to transmit the shares. Now this judgment which you are relying upon is like the court says that people will garner shares from, is it a public limited company or is it a private limited company? In the case of the Hindustan,
earlier they were all
Bank of Hindustan.
Earlier they were all public limited companies on Zilla. Can you show me? But everything boils down to the memorandum and articles of association.
The Bank of Hindustan
And in our case,
also talks about, 1 minute, also talks about a section 34(7) of the Company Act. I'll read that out. That section I don't think is in the Parent Companies Act. Section 34(7) says, nothing in this section shall prevent, prejudice any power of the company under its articles to refuse to register the transfer of any shares. So that power was there with the company.
it's there even today, Lordship.
No, it's not.
Lordship, I can refuse to transfer. Let me show me, Lordship, articles. Under the Companies Act, Lordship, can I show the article?
And secondly, in the second case which you have given, here in the memorandum of association, there is a clause. The directors are at liberty without showing any cause to refuse to transfer any shares in the name of other persons. The company can refuse to enter the transfer. Do you have any such similar clause in your AOA or MOA?
Yes, Lordship. Yes, I will show, Lordship. Lordship is asking me question.
We'll go through that. We'll go through that.
Lordship will kindly come to show me that transfer clause. Page 56, Your Lordship is 56. Lordship, these are there. 56, Your Lordship will kindly come to 56.
The malice,
Yeah, you know.
fight which they have take this because that is also allowed as per this judgments at the Bank of Hindustan.
Lordship, may kindly have.
They should case that.
No, he is pleading malice on the ground that this is a
Lordship, may kindly have 56.
No, he's saying he's a competitor. If you say non-compete, I will register. That's the only clause. He's not saying I will not register. He says, give me non-compete, I will register. Okay.
Lordship, may kindly have, to answer my honorable member's query. Article 25, page 57. Any person this is there in the model articles also. Lordship, may kindly see. Under the Companies Act 2013.
This is your articles of
Yes.
association, page 27.
Page 57, Article
1 minute,
25.
1 minute.
Yes.
It's a new article?
Yes,
I'm,
yes.
I'm seeing your first one.
No, Lordship may kindly have this current one also because this is in line with the 2013 Act also. Lordship will kindly have Companies Act 2013 where I will show in the model articles of association this is there. Lordship may kindly have page 57-25. Any person becoming entitled to a share in consequence of death or insolvency, here also, of a member may upon such evidence being produced as may from time to time properly be required by the board and subject to hereinafter provided elect either to be registered himself as holder of the share or to make such transfer of the shares as the deceased or insolvent member could have made. This is important. The board could have, as the deceased or insolvent member could have made. The board shall in either case have the same right to decline or suspend registration as it would have had if the deceased or insolvent member had transferred the share before his death or insolvency. So therefore, all the conditions which were there in a normal regular sale are applicable even in the case of transmission of shares by death or by insolvency.
But Mr. Nagar,
I have
that's
no
not really
Correct.
You see, what you are saying is in the normal course
That's
of,
right.
in the what would have happened in the case of normal transfer. Now go to Article 21.
Normal course,
Normal course, only two provisions are there for the board to refuse to register.
22, Lordship may kindly have 22. No, 22.
21, just about 22.
20. Lordship may kindly have both. Lordship, we have to read everything. The board may decline to recognize. Lordship is reading 21. The board may decline to recognize any instrument of transfer unless the instrument of transfer is in the form as prescribed in rules made under subsection 1. The instrument of transfer is accompanied by the certificate of the shares to which it relates to such other evidence as the board may reasonably require to show the right of the transferor to make the transfer, and the instrument of transfer is in respect of only one class. Lordship, may kindly pause here for a moment. No instrument of transfer. This is instrument of transfer. Lordship, this relates to instrument of transfer. Lordship may kindly see. Lordship may kindly have, because in articles of association we have to read it very. This is only the board may decline to recognize any instrument of transfer. Suppose somebody sends an instrument of transfer, they saying the board has power to decline the transfer provided these conditions are met. Lordship may kindly note. That's for the
21 is to be read with 25 subclause 2.
No, Lordship 22 cannot be ignored like this, with due respect.
No, 22 is there.
21, 20, we are reading everything. We are reading everything. 21, 22, 20, Lordship may, let me complete with 22. None of the shareholders, Lordship may kindly see, this is binding on the shareholders.
That you have read.
No.
The earlier one is the same one.
Same, Lordship may kindly see, shall sell, transfer, assign or pledge, encumber or otherwise in any manner dispose of its share in the company to an affiliate or to a third party unless such affiliate or third party agrees to be bound by all the rights, obligations and liabilities of the transferring party pertaining to the transferred shares, comma, including those defined in the memorandum articles of association. And therefore 25 reads, 25 Your Lordship, this 22 is applicable to 25 also. That is the reason it says the board shall in either case, I am reading 25 Roman 2, the board shall in either case have the same right to decline or suspend registration as it would have had if the deceased or insolvent member had transferred the share before his death or insolvency. So the same thing applies here, because A, it is first the condition of the shareholder you are not supposed to transfer, and then the board has the right to refuse the transfer, because Your Lordship, we will see any
That
sale.
right to refuse is specifically laid down in Article 21.
Lordship, that is with due respect.
What you are saying, you are trying to say that this right to transfer, refuse transfer, is also to be ingrained in this article. 22 has to be read along with 25 too.
Yes.
That's what I'm
That's correct. That's
According
correct.
to me, it is already there in 21. So 21 is what is relevant.
21, in my humble submission, Your Lordship, it's only instrument of transfer, not otherwise.
20 also, yes.
20
and 21.
Under which it can be declined.
Yeah.
That if it is a partly paid share, or
Someone sends an
if
instrument of
it is a
transfer
share
without
on
the
which the
documents.
company has a lien. In fact, my submission is,
reasonably
except
required
in
to
case of
follow the
20 and
transfer.
21, no registration can ever be declined.
No, let's read 21B. My learned friend, if that is the case, Lordship, may kindly say 21B. Let me read 21B. The instrument of transfer is accompanied by the certificate of the shares to which it relates. Lordship, may kindly see comma, and such other evidence as the board may reasonably require to show the right of the transferor to make the transfer. How is my learned friend showing the right of the transferor, saying that without complying, Lordship, may kindly say rights of the transferor is 22. Lordship, may kindly see rights of transferor flows from 22, Article 22, because it says that the shareholder cannot sell or transfer. Lordship, may kindly read, these cannot be read.
Mr. Makkar, did you write to this company to register your shares?
Absolutely, Lord.
What, did you get any reply from them?
No, Lord.
Okay.
None whatsoever.
No assets
That is
for
why we are
no
before Your
shares.
Lordship. Lord, that's my whole petition. That 1.5 years I have had these shares, Lord, I paid for these shares in September 21. Till today, my transfer in my favor has been blocked. On one hand, Lord, transfer in my favor has
But
been
then,
blocked.
but
On
then
the
there
other-
is a catch.
Yes.
What is the date on which you wrote asking for transmission of shares in your name?
Immediately after, Lord, my sale was approved in my favor, September 21.
21. Now,
10 days after that. 12th October 21 is the formal communication to them that
the
please register
instrument
this
of
transfer
transfer
in
is
my
accompanied by certificate of shares.
Yes.
Did you produce the share
No,
certificates?
Lord, I did not. But the liquidator wrote to them that these shares are lost. Kindly issue duplicate shares so that the formalities could be completed.
He replied to liquidator.
That we replied. I'll show the reply. MGT
Now,
5
Lord,
which
the
was sent
fact
was only
remains
beneficial
my learned
interest.
friend today has declined to register these shares in my favor on one ground or the other, and now the ground is I'm happy to register provided you agree to remain bound by JVSP. So the short question to be decided by Your Lordship today is, can this be made a condition precedent to this transfer?
JV is page 11?
That page
Page
11.
Page 2 at 11.
starts at page 2 at 11.
Non-competition.
For that, I am only relying on one judgment, and I have given that not extracted
Joint
that paragraph
ventures.
in the note that I have submitted. This judgment, V.P. Rangaraj, if your Lordship kindly sees, I have extracted this in the
Overruled
note
by
that we have
larger bench.
submitted.
We did that. Let him cite that.
Your Lord may kindly have this judgment. And my Lord, there is a very recent Delhi High Court judgment saying that this judgment still holds good. Ratio, this judgment still holds good.
31 is para 7.
If your Lordship has para 7 of this judgment,
One minute, let us see this clause.
and your Lordship will also bear in mind, my Lord, the objection regarding the binding effect of JVSPA was also taken before the appeal court and not entertained.
So this joint venture and share purchase is Macromedia purchases about 55% shares.
I'm sorry, Milord?
Yes.
Macromedia SA purchases
55%, yes.
55% approximate shares of HPP India.
Correct.
Yes. Out of which 47% is now sold to me.
Yes, 47.
So this is
There is
this
some-
agreement, Milord, JVSPA is signed and executed between Macamidi, the Indian arm of Macamidi, and the erstwhile promoters now who have sold off their shareholding to Milord, this Global Energy.
Now, my learned friend should also say the company is a signatory to that agreement.
Huh?
The company is a signatory to that JV agreement.
Correct.
It's not that the company is not a signatory.
Milord, if your
My
Lordship
learned
has
friend saying
yes,
the
yes.
super,
Para 7, if your Lordship kindly sees, Milord. Para 7 of this judgment, Milord. I think this sets
No,
the
but
controversy
let us
at rest,
see-
Milord.
Let us see the condition 11.
Yes, yes, sir.
Milord, if your Lordship kindly has para 7, even I assume that this condition is there in the JVSPA.
No, let us see. Read
Yes.
what it is, then we'll go.
Yes,
This is Article 7, right?
Yes, page 11.
Yes, yes, I'll read that.
You read it?
Article 7. Non-competition from Macamidi Group. Macamidi hereby undertakes and shall cause its affiliates to undertake, this is Macamidi SA, to stop and not participate or engage throughout the duration of joint venture company directly or indirectly any sales related to the same business within India, Bhutan or Sri Lanka. So now this is an undertaking by Macamidi SA that we will not, having purchased shareholding in this Indian arm, 55%, we have purchased 55% shareholding of this Indian company. We will not.
1 minute. There is a totally different way to look at this.
Your Lordship is absolutely right, my Lord. This is an undertaking by them that we will not compete with
That,
this Indian
that
company.
company is now gone.
That company is dead and gone.
In liquidation.
Mr.
That
Nagesh,
company does not exist anymore. That company is liquidated.
No, Lordship, that is the reason I am saying that
See,
you have to read Article
here-
22, we read with 25. Insolvency.
you are saying
Yes.
he has to inherit the legacy of a dead person.
Dead company.
That is the reason 25 comes into play.
And
Lordship.
where
No.
I inherit, that court
Insolvency.
declines your request.
No. Please don't confuse the issue. Please understand this. Macromedia SA was a now is not. It
Is
was
not.
a company
Yes.
which was handling similar hydro technology throughout the globe.
Across the globe, yes.
And therefore, when you wanted them or they wanted to come into the Indian company as a partner, this JV was entered because Macromedia was already in the same field. You said, please don't enter into India, Bhutan and Sri Lanka.
That's right.
So therefore, this was signed. The moment Macromedia dies, this JV dies.
Your Lordship is absolutely right.
Macamidi is undergoing liquidation. It has not, in that sense.
It's now
Company is
liquidation company means what is liquidation? It's a death.
Death of a company.
You know
By
that.
operation
law.
of law.
Liquidation is the death of company's closure. All it has to go is end this, remove the name from the.
That is the reason Article 25 was placed, Your Lordship, in this case. Article 25 says the same
So
thing.
once that non-compete is relating to a company which is now a dead company, where is the question of imposing something which is there? Now the question is the share is being sold as such. Now it is purchased in open market by a person. So that is what Mr. Makkar is trying to say. What arrangement you had with a company which was alive then? Now it's a dead company. So how does it really matter that what you had arrangement with him will close with the company? That's all. That company will not compete with you. That company is now lost. It's no more alive. So you have a right only so long as Macromedia SA is alive to say Macromedia should not compete with you. But if it sells the shares out of otherwise than liquidation, then your clauses say he cannot be sold without, that article says that. The Indian company's arm should be taken into consideration. The board should authorize, because the sale cannot happen just like that to a third party. Because then comes Justice Rajamannar's judgment.
Yes.
You cannot sell it to somebody to kill this company, mischief maker and all that. So McAmeedy SA could not have unilaterally sold it to Flowell, for example.
Yes.
Earlier they were bedfellows, now they fell out. So at that time they could have sold it and made a mischief out of you. But that was a condition which Justice Rajamannar judgment will apply. But in a case where the entire company globally has gone into liquidation, whatever has been signed inter se will have to, it has to see a natural death. Those agreements will die a natural death. Then comes the sale to a arm's length to a third party. Now that third party is Flowell. It can be anybody, it can be any other company, even your global whom you sold, they could have purchased it. So if you say that this JV agreement will be binding on them, then that makes a mockery of, because that dead company's this joint ventures agreement will be given a life. How can we give life to that?
Lordship will kindly have 57.
Just
57,
one more
I'll
point,
answer
sir,
that.
Lord. Your Lordship will also bear it in mind, Lord. This objection regarding JVSP was one of the grounds of appeal before the Paris Appeal Court, and that this objection was
Yes,
not
sir.
entertained by that court.
No.
I
think you are making ground statement. Please don't say that.
Your Lordship may kindly
It's
see
not
that
that.
part of the order.
Again,
Kindly see that part
you're
of the
going
order.
back and forth saying that
if I'm
it was
making a wrong
Nagesh,
statement, I'll make that
if I-
statement
if
good
I-
in a minute.
No. I do remember that we read the appellate court
Yes.
order on that.
This was one of the objections which has not been.
Lordship, if
Can
I
we go through that again?
appeal
For
is,
your-
appeal
for
is
your-
allowed.
Will
Appeal
not
is
make-
allowed.
yes.
Well, Lordship,
No, just
either,
no, no.
okay.
Allow me to
Please
clarify
clarify.
this.
Don't
One
make a
minute.
mistake in
Yes.
reading that
I'll
order.
clarify this.
Please. We saw the grounds of appeal, didn't we? Was it not there?
Yes, it was there. It is in the operative part of the order. That's what I am saying, my lord. Kindly see CA 291. My lord, the order starts at page 11. Kindly see page 15.
The only problem is that, is it the same volume?
No, my lord, this is a different one than IA, my lord. IA 291. I will not trouble your lordship with any other volume except that one. Kindly come to page 15, my lord. Yes.
Court of Appeal, Paris.
Yes. Order starts at page 11. I am reading page 15, my lord, from top. Second line. The company Flowell Hydro Technologies Private Limited and the judicial liquidator argue that the appeal of the companies Macamidi Italia and Macamidi India is inadmissible on the grounds that they were not parties to the proceedings and their rights and obligations are not affected by this decision. The companies Macamidi India and Macamidi Italia respond that their rights were affected by the order of the Judge Commissioner who authorized the transfer of the securities held in their share capital for the benefit of third company, namely the company Flowell, which does not respect any of the contractual provisions provided for in their articles of association. They indicate, first of all, that the articles of association of company Macamidi India provide for an approval clause in article 22 and 25 of the articles of association, precisely what is being argued today, my lord.
These are arguments, not submission.
Clarify,
Clarify, these are submissions.
I'm
say so that.
coming to the operative part. These are submissions being recorded by the courts. 22 and 25 of the articles of association. However, article 22 and 25 do not appear in the articles of association, but in a memorandum. Now, this memorandum is this JVSPA. In a memorandum not translated into French, and following document translated into French is difficult to read and entitled Articles of Association provided in its articles volume 7 that the holders of shares may not only sell shares to a third party on the condition that the transferee agrees to be bound by all rights and obligations and responsibilities of transferring party concerning the transferred shares which does not amount to right of preemption. The documents referred to being written in Italian is not translated. It is in these circumstances that the present court ordered that the companies Macamidi India and Macamidi Italia to submit the proceedings legible translations in correct French of all foreign documents submitted in the proceedings. Now kindly
No,
skip
please, no.
Okay, I'll
Please read the
everything.
next one.
All right.
Read the next one.
At the hearing of 7th
Ah.
September 22, to which this case was referred, if no French translation was sent, nevertheless the judicial liquidator acknowledged by way of conclusion the existence of
approval clauses.
Just one
Yes.
minute, please.
No, you were skipping this
All
line.
right, I will not skip any line. It follows that the action brought by Mecamidi HPP India Private Limited and Mecamidi Italia, to which the order referred to has been notified, should be declared admissible. So, Your Lordship will kindly bear in mind the appeal was filed by none other than Mecamidi India. On merits, the appellants argue that the approval and preemption clauses preclude or authorize assignment. The order of Judge Commissioner authorizes the transfer and securities for the benefit of the company Flowell, specifying that the letter which will have to deal personally with the dispute relating to transfer of securities, the court considers that in order to preserve the rights of each party, it should be specified that the authorized transfer must take place in compliance with the statutory clauses of the company, Mecamidi HPP India Private Limited and Mecamidi Italia, and more generally of the law applicable to these transfers. For those reasons, declare the appeal filed by the Mecamidi India as admissible, confirm the order, adding to this, the said transfer must take place in compliance with statutory clauses. So, my lord, all this is considered there. So they are now having a second bite, my lord, at the cherry by re-agitating the same argument which was considered by the Paris Appeal Court.
It says statutory
Lordship,
clauses
yes,
of the company.
my appeal has been
Statutory
allowed
clauses means, my lord, articles of association.
statutory-
Which I am saying I am bound by,
in compliance with the
but
statutory.
not by any JVSPA.
Lordship, may kindly see. And more generally, the law applicable to these transfers. The law applicable to these transfer is under the Contract Act, Your Lordship, that any contract signed between the parties which contains a preemption clause or a non-compete clause should be admissible. That's what he says. Your Lordship, applicable laws. We cannot rule out that the Contract Act prevailing and for the JV should be ignored. He's saying everything should be complied with. That is the reason he confirms the order. Adding to this, the transfer must take place in compliance with the statutory clauses of the companies, Mecamidi HPP and the companies, and more generally the law applicable to these transfers. The law applicable to this transfer is governed by the Articles of Association, and the Articles of Association clearly say that any conditions which the transferor has to comply with, even the transferee has to be he has to comply with that.
There is no
So
quarrel with the
therefore,
Articles of Association.
I'm saying, Your Lordship,
There is no quarrel.
therefore, Your Lordship, and Lordship, my learned friend has judged that B.B. Rangaraj judgment is completed or
No,
you
Your
read that.
Lordship has paragraph 7 of this judgment.
So 1 minute.
And this is, my lord, in support of the contention that whatever may have been contained in JVSPA, without prejudice to my other argument that it doesn't bind me, as long as that those conditions are not incorporated.
Articles of association, unlike this 21, which are the articles, clauses of the articles of
22, 25,
20?
Article 22
22,
and
25, page 56, 57.
And my lord, the technical member also referred to 20 and 21.
I am on page 44. There are so many articles. So
Which one do you would like us to read? The
Lordship,
latest
the
one?
French,
There are 3 articles of session.
Lordship,
Lordships can have page 56 and 57. There is no difference in the clauses. The only change is as per the 2013 Act. The new set of
No.
articles.
So my friend relies on 22 and 25. My lord, the technical
Page
member
number.
also referred
Page
to
56, Your Lordship, of the convenience
volume one.
compilation.
because there's one more in page 44.
Lordship, there are 3 versions, 2012,
Your Lordship will take this
2015
version.
and
Lord.
2017.
What is
The
being
clauses
relied
are
on?
same.
There is
At
no
least you
quarrel.
should have written, no, which version is this? Page annexure 5.
Index it is there,
Page
Lordship.
40.
Index, Your Lordship, it is the set of articles adopted in 2017, page 50 to 71. Page 50 to 71. Your Lordship will kindly have page 56.
So
Serial
you are in
number
2017.
6. Yes. Serial number 6, adopted in the year 2017. Your Lordship will kindly have page 56 and 57.
So there are 22, huh?
Yes, 22 and 25.
Board may decline to recognize any instrument transfer if this is not then prescribed under subsection 1 of section 56. Form prescribed in the rules made under 51. So that form has been submitted.
No, Our case is that form has
Yes,
not been
yes.
submitted.
Of course it has been.
Lordship, then therefore I'm saying your Lordship may deal with 58 first.
Yes.
Because all these issues will be considered. Whether the form has been submitted, I'm saying no, he's saying yes. What
this
form
is a
has been
list of
submitted,
dates.
whether I rightly refused it. Your Lordship may kindly that. No SH4. Lordship, under the Companies Act
Page.
2013,
Page.
you will have to submit an SH4 for the purpose of transfer. What they did was the liquidator sent an MGT5 saying that he is the beneficial interest because the liquidator auctioned the shares, your Lordship. So he's saying that please recognize them as a beneficial holder of the share. No SH4 has been sent. So therefore,
My Lord,
that
that
argument I will
let that
take.
technicality not stand in the way, my Lord. We will comply with any kind of form that is required to be submitted. If the form we have submitted is not correct, we will submit any other form that they want us to.
Let him show a form.
My Lord,
Lordship, now today we are in the court and my
Yes.
learned friends say that if anything has to be complied with, I will comply with. Then what is the grievance he's having then? Then it's premature then his petition. Lordship, I kindly see that. So
my Lord,
today,
SH4 couldn't have been submitted in the absence of original share certificate. Therefore, I submitted that form which is required to be submitted as if I am the beneficial owner of those shares. Now those shares are lying with this court. Your Lordship will make consequential direction. Once your Lordship decides the question, my Lord, whether I am entitled to have these shares registered in my favor, rest everything will follow, my Lord. Those are all technicalities and modalities of how that order is to be implemented.
But Mr. Makkar, you
Yes.
should understand one thing. Before we started on this, you should have thought about all this because you cannot ask us to hear a petition unless it is filed, cleared, numbered. Similarly, a company cannot even rule on something, like for example, whether declining, for example, under 22,
correct. Or even 21, your Lordship.
21
Or 21.
cannot
yes.
be done unless you present that in the form. Okay. You say that original was not with you because Mr. Jean Zekri was hiding that somewhere. So you got the sale but only letter of the liquidator. But still then you could have said these are the now shares, that column should be blank. Please have it transferred and the liquidated letter should be enclosed.
I did. I submitted what is called Form MGT4 as beneficial owner of those shares. Now, my Lord, when they did not register, I came to this court. Even in this court, my Lord, their response is not that I did not submit the requisite form, therefore they did not register. Their response is, no, you are not entitled to seek this registration.
No, both.
You can't seek
Both,
this
I think both.
transfer. Kindly see, my Lord, I have submitted this form, my Lord, way back on 12th of October. 20 days after this, my Lord, the sale was approved in my favor, page 334.
In your notes have you said?
Yes, page 334. In my notes I have said so, my Lord. In the list of dates also. If your Lordship kindly has list of dates, 12th of October. Yes, Flowell addressed a letter to MHPP enclosing therewith the following. My Lord, in the list of dates, your Lordship will see at item number 19. Yes, list of dates handed over today, my Lord.
Today.
Item number 19. My Lord, this loose compilation I gave to your Lordship today. List of dates, my Lord, it's something like this. Yes. Kindly see 19. Flowell addressed a letter to MHPP, which is at 334 of convenience compilation, enclosing therewith the following copy of resolution dated so and so issued by MSA's liquidator appointing Mr. Satvir Singh Sarot and failing him Mr. Hitesh Chaudhary as authorized representative, copy of form MGT4, MGT5 and BEN1 pursuant to section 89 and 90 of the Companies Act. These are the forms that are required to be submitted if I do not, for some reason, have the original share certificate. Now, my Lord, this is a mere technicality. It is not my friend's case that if I submit the correct form, he will, my Lord, let him make a statement, I'll submit whichever form he wants me to submit. He is questioning my right to have this transfer in my favor. Yes. And my Lord, your Lordship knows the share certificate, when the physical form share certificate is to be submitted, that is required to be submitted with a necessary endorsement by the transferor, which in this case would have been the liquidator. Liquidator wrote to them that please issue duplicate shares in the meanwhile because I don't have those shares. Now, my lord, as far as JVSPA is concerned, my lord, just to conclude my submission, if your lordship has para 7 of this judgment of VB Rangaraj, my lord, without prejudice to my other argument, my lord.
Yes, sir.
Para 7, my lord, internal page 164 on top, your lordship will see. These provisions of the Act make it clear that the Articles of Association are the regulations of the company binding on the company and its shareholders, and the shares are movable property and their transfer is regulated by the Articles of Association of the company. Whether under the Companies Act or under Transfer of Property Act, the shares are therefore transferable like other movable property. The only restriction on the transfer of shares of a company is as laid down in the articles, if any. A restriction which is not specified in the articles, if therefore not binding either on the company or on the shareholders. The vendee of shares cannot be denied registration of shares purchased by him on a ground other than that is stated in the articles. So as long as the conditions regarding JVSPA are not incorporated in the articles, I cannot be, my lord, those compliance with those conditions cannot be made a condition precedent for recording this transfer. Now, my lord, I have also given in my note, which may not be necessary, but, my lord, recently there was some confusion, my lord, in subsequent observation in another judgment where, yes, in Vodafone, my lord, which cast a doubt on the validity of these observations. My lord, recently Delhi High Court has held in this judgment of HTA employees that this is still good law. If your lordship has para 19 of this judgment of Delhi High Court,
you see, in this Justice Savan's judgment, what I was expressing earlier is being again and again reiterated even in English law, that a share is a commodity which is really
tradable,
transferable and tradable. That is how the economy of the country, the corporates run. Because the shares, unless the article, that is, restriction should be imposed in the articles. There is no difficulty on that. So to what extent we have to read? Now Mr. Nagesh wants to
Lordship,
read.
shareholders enter into an agreement in the interest of the company. Lordship may kindly note the interest of the company is paramount. It is not this non-compete clause is not in my favor, Lordship. It is in the best interest of the company. I don't want my competitor to compete with me in the business. So when he becomes my shareholder, I say, please give this non-compete clause so that you do not compete against the interest of the company. I have no personal interest at all. The shareholders, it is in the interest of the company. Therefore, your Lordship, or most of the joint venture agreement, if your Lordship may kindly see, where the company is also party, they will have this restriction, they will have this covenant to say, neither of the party shareholders will sell the shares to another competitor. And that has been set out in Vodafone judgment also.
There was no restriction on transfer. In our case, Article 22
Show me that. Maybe there is no. Maybe Rangaraj case.
So it is.
Maybe Rangaraj case, but there is no restriction.
For the purpose of individual transaction may happen. So these contracts are individual specific. That is between the two parties. That is different from articles of association. So this is why that sound judgment which is there. So this company can enter into different transactions, JVA or otherwise, for the purpose of either business or finance or something. So there they may have different types of. So that JVA will be that party specific. Right. That's about it.
And therefore, Lordship is absolutely correct insofar as the shares which are freely transferable. But the shareholders are conscious of the fact that the interest of the company is paramount. Therefore, Vodafone judgment, Your Lordship, V.B. Rangaraj judgment, which my learned friend cited, my learned friend also cited the Delhi High Court judgment, Your Lordship, saying that
judgment is only to show that V.B. Rangaraj is still good.
Mr.
But
Nagesh,
yes.
if the interest of the company was paramount, then why did Sanjeev Kapoor and this other Singh, why did they have a non-compete clause for themselves only for 5 years?
No, now we have given, Lordship may kindly see, when we sold the shares, Lordship may kindly see, this company...
For the French company, you said it will be for in eternity. For themselves, for the Indian arm, they said it will be for 5 years.
Correct.
So therefore, after 5 years, they could have started doing other businesses which will be competing with this company. So the interest of the company, is it paramount?
Lordship, one thing is the commercial understanding, the second is the interest of the company is paramount, and therefore, Your Lordship, I gave a non-compete also. I'll show you another one. Recently, you also gave a non-compete to MHI. MHI sale करते समय भी non-compete किया था ना आप लोगों ने.
But in fact, they sold their entire shareholding to a competitor.
No, I'm a shareholder in that company. Please, let's not.
They have become shareholders in that company.
So I'm not a competitor. It's my own company. So there's no competition between us now.
So in consideration of sale of these shares, they have acquired 49% equity in that company and received cash. So
no.
Does the sale not amount to sale to a competitor?
Okay, let my friend file an affidavit that I've taken cash. Let's not say anything.
That's your
of
agreement.
that.
It's on record.
No cash has been received by me. I'm saying on
Consideration, not cash, consideration.
Now don't change your.
Very well. Not cash consideration,
Now
not
you're
cash,
saying
money.
consideration.
All right.
Let's be clear. We are in
All right.
court and we have to be clear what we are saying.
All right.
I'm saying that no cash has come. Lordship may kindly see this.
It has come through check.
Particular aspect of V.B. Rangaraj was considered by Vodafone by subsequent judgment of Honorable Supreme Court, which Lordship will have a binding effect not on the Delhi High Court judgment, which is saying that it's a Delhi. Lordship may kindly have this Vodafone judgment which I am giving very clearly, because Lordship, everybody says that memorandum articles of association paramount. I'm also saying the same thing, but you cannot say that the joint venture agreement Vodafone. I just read it.
No problem.
Lordship will kindly have page 714.
कोई बात नहीं.
262. Lordship has that? Page 262. Para 262, page 714. May I read your Lordship? The nature of SHA was considered by a two-bench judge of this court in B.B. Rangaraj versus B.B. Gopalakrishnan. In that case, an agreement was entered into between shareholders of a private company wherein a restriction was imposed on a living member of the company to transfer shares only to a member of his own branch of the family. Such restrictions were, however, not envisaged or provided for within the Articles of Association. This court has taken the view that provisions of the shareholders' agreement imposing restrictions even when consistent with company legislation are to be authorized only when they are incorporated in the Articles of Association, a view we do not subscribe to. The Vodafone judgment is not subscribing to that view. Now, Your Lordship may kindly come to the next two lines. This court in Gerula Parekh versus also held that freedom of contract can be restricted by law only in cases where it is for some good for the community. The Companies Act 1956 or FERA regulation do not explicitly or implicitly forbid shareholders of a company. This is important, Your Lordship. Do not forbid shareholders of a company to enter into agreements as to how they should exercise voting rights attached to these shares. 264. Shareholders can enter into any agreement in the best interest of the company, but the only thing that is that the provisions in SHA shall not go contrary to the Articles of Association. As long as they are not contrary, Lordship, they are enforceable. The essential purpose of SHA is to make provisions for proper and effective internal management of the company. It can visualize the best interests of the company on diverse issues and also find different ways not only for the best interests of the shareholders but also for the company as a whole. So therefore, Your Lordship, I am saying B.B. Rangaraj has been held not to be a good law Lordship in this case, and they say that listen, you can have a shareholders agreement as long as it is not inconsistent with the memorandum articles of association of the company, and this has been consistently held, Your Lordship.
No, in B.B. Rangaraj, was there a shareholders agreement?
Article 22.
Sorry, Lord.
Shareholders agreement was there?
Yes. Now, Lord, there was V.P. Rangaraj was a very, very general statement. Now, my lord, the only answer to my learned friend citing
No,
Vodafone
no, no.
judgment
Let
is
us see whether there is a
yes, my
shareholders.
lord. B.B. Rangaraj.
No, no, your lordship, it's a BB Rangaraj.
Yes.
I have 16 lordship.
Para 16, page 166.
Yes, my lord. If your lordship sees the head note, there was an oral agreement between the two brothers that each branch of the family would always continue to hold equal number of shares, that is 25, and if the number of either of the branches wished to sell shares, he would give the first option to purchase to the... So, my lord, there was a family agreement. They said whatever is not incorporated in the articles cannot be enforceable.
No, no, please, where is that?
There is no transfer restriction in BB Rangaraj's case, your lordship. And we may bring it, your lordship, notice page 60, para 60, page 166. Your lordship may kindly read that article. Unlike in our case, there was no restriction there. Lordship may kindly have page para 16. The article reads as under 13. No new member shall be admitted. Lordship has that. Page 166. Para 16, I am reading article 13. No new member shall be admitted except with the consent of the majority of the members. On the death of any member, his heirs or nominees shall be admitted as member. If such heir or heirs or nominees are believed to become members, such share capital shall be distributed at par among the members equally or transferred to any new member with the consent of the majority of the members. Lordship may kindly see, there is no restriction in this, in the manner in which our articles have. Our articles are very clear. Article 22 and 25, which say that it cannot be transferred. None of the shareholders shall sell, assign or pledge.
My lord, your lordship wanted to see the reference to the private agreement in B.B. Rangaraj, para 18, my lord. Hence, the private agreement which is relied upon by the plaintiffs, if your lordship sees the last paragraph, it makes the reference to that, my lord.
That's oral, no? That's oral agreement, your lordship. That's what I said. There is nothing in writing.
Absolutely. Go and remove the card.
இந்த ஏசி குறைக்க மாட்டீங்களா?
किसका है ये? नहीं ये नहीं है।
Number different. So long as you are member, you can also spread. So long as the JV is in there, this follower, then this agreement will be good. Now let us go to liquidation from the So that strictly not related to the shares, it is related to different companies.
That's what the parallel paragraph shows.
So it's transferred to third party. So if you want that can be includes later on. Because like your company is running, when you wanted to add somebody, then you add somebody into JV. But here it is a purchase of the shares. So the JV clause doesn't go to the shares. So what is the 54% going to mechanism? France. So rest of the shares are not in the non-compete clause. It is 5 years for somebody. So it is only included specifically. It doesn't travel with the shares, it travels with the party. So therefore this non-compete clause will not bind a third party who is not a signatory to the JV. Yes.
So I was mentioning about the Vodafone judgment, Your Lordship, which expressly stated that you can have a joint agreement, Your Lordship, which I just handed over.
That share SHA is share
SHA is a document, Your Lordship.
shareholders
Here
agreement.
it is a shareholders agreement. Here it is a shareholders agreement.
What was the cause for that issue in Vodafone SHA? On facts, what was that?
I'll just see that. Just show me. There was a shareholders agreement which contained that clause, Your Lordship. Wanted to see what is that.
No.
Ah.
Why that issue was raised in 262 and 264?
Yes. I'll just.
The differentiation between the Judge Rangaraj's case when the Supreme Court said that we do not hold such a view, that meaning thereby, even if there is an articles of association on a particular manner of internment between the company, still then there can be an agreement amongst the shareholders to do or not to do certain things.
Correct. Lordship is right. Where is this?
Was to regulate the ownership.
Huh?
Lordship, in this case, the core issue was regarding the taxability of the sale which took place outside India. So Vodafone had operations in India. The shareholders were located outside India. So that was the issue, and the reason why it took place outside was because there was a shareholders agreement which necessitated that it had to be done in a particular manner. So in that context, the issue arose whether that shareholders agreement will be enforceable or will be taken into account or not, or only the articles have to be seen.
So the Supreme Court held that such agreement was valid?
Yes.
Obviously.
Yes. Oh, Lordship. That's the. I was reading that. It is. It is.
and the shareholders was live and subsisting.
Lordship?
Such shareholders agreement was live and subsisting.
Yes. Yes, yes. Your Lordship may kindly see, that is the reason every time Your Lordship asks me this question, I'll bring Article 25. That's
Article
it.
25.
That it applies to insolvency. Page 57.
I'm still not able to
Yes.
understand what you want to impress upon that Article 25. Let's read again. Any person becoming entitled to a share in consequence of death or insolvency
I'm
of
on
a
the
member
insolvency, Lordship, of a member.
may
because-
upon such evidence be produced
As may from time to time properly be required by the board and subject as enough to provide elect either to be registered himself as holder of the shares or to make such transfer of the share as the deceased or insolvent member could have made before his death. Now, the could have made before his death. Now, the board shall, in either case, both scenarios, have the same right to decline or suspend registration as it would have had if the deceased or insolvent member had transferred the shares before his death or insolvency. So, I have the same rights, Your Lordship, which were existing under my joint venture agreement to refuse transfer, even if a member transferred the shares pursuant to the shares have transmitted pursuant to the death or insolvency.
See, let us put it little more precise. Mr. Makkar, this is his point. If Maccamedia SA wanted to transfer the shares to Flowell, assuming hypothetically, there would have been a restriction on registration by Flowell HPP India in terms of 25, because he would refer to the contract
Yes, 22.
JP SVA 22 and say that you have already signed it. So unless this transfer is effected along with that condition of the JVSPA, you can't transfer. If it was not, if that condition could be imposed on Maccamedia SA
Yes.
prior to insolvency,
Yes.
post insolvency also, they are saying 25 can be invoked, that post insolvency, if a person becomes entitled share like Flowell as a consequence of insolvency of Maccamedia SA, upon such evidence being produced, that is the liquidator's order for transfer and
Yes.
other things, the board, subject to hereafter provided, elect either to be registered himself or transfer. You want to transfer. Now you
Yes.
are asking for transfer. The board shall in either case have the right to decline or suspend registration, decline or suspend, as it would have had if the deceased or insolvent member had transferred the share before his death or insolvency.
That's
So he
right.
says, I have a right to decline or suspend the registration,
Yes.
because on the ground that he can say 101 things, including the SP, JVR or JVSP.
Yes.
So this is his core point. Let us focus on that, nothing more.
Yes, I'll straight away answer that. This was page 70,
57.
57. Now, my Lord, if your Lordship kindly sees 57, what he is relying on. Any person becoming entitled to a share in consequence of death or insolvency of a member. So, my Lord, I take it that I am becoming entitled as a consequence of death of the previous shareholder, that is Maccamedia SA. Although I become entitled to these shares by operation of law, but I assume that this clause applies, although it doesn't.
No, insolvency.
Very
It
well.
says.
This was liquidation, not insolvency. Insolvency is quite different from liquidation.
The new twist you are giving. Okay,
Yes.
all right, let's go
This was a
forward.
case of liquidation.
Liquidation.
So assuming for the sake of argument that this clause does apply,
So
what
your
does it
point
say?
is- Your point is if it is a member of
That's
the
right.
company, he continues as a
That's right.
company.
Liquidation means legal death of the entity. It does not exist anymore. Assuming for a minute, my Lord, I'll still make this argument. Assuming for a minute this clause has application. What does this clause say? Any person becoming entitled to share in consequence of death or insolvency of a member may, upon such evidence being produced, as may from time to time properly be required by the board, and subject hereinafter provided, elect either to be registered himself as a holder of shares, to make such transfer share as the deceased or insolvent member could have made. The board shall, in either case, have the same right to decline or suspend in the registration as it would have had if the deceased or insolvent member had transferred the shares before his death or insolvency. So the same right would have emanated only from the articles, not from JVSPA.
Why?
Not the right of the board to suspend any transfer or to decline any transfer is contained in Article 20 and 21. Those are the only circumstances where a transfer can be declined.
That's why he is relying upon JVA, Vodafone.
No, my lord, Vodafone does not say that you can decline transfer even beyond that.
No.
Yes.
Vodafone says that a shareholder agreement also will hold good.
I'm sorry, my lord.
Shareholder agreement also will
Not
hold
for
good.
the purpose of declining transfer. I will just read this paragraph, my lord, from Vodafone itself. Firstly, my
That's
lord,
why I wanted
yes.
and what circumstances.
Firstly, my lord,
is
your
that-
lordship will kindly see one thing, one nuance of Vodafone judgment.
Jai, we'll do
This
one
was
thing.
a 3 judges
We'll do
judgment.
that. We have spent enough time on that.
Yes.
So now with this today's argument, both of you have now changed the tact, or in the sense, at least you have come to a more.
My lord, I am
critical.
happy to conclude my argument in next 3 minutes. My lord, I have nothing more to add in this.
No, we will see that Vodafone explain. Lordship has got the list of the arguments.
Yes, but if
25,
your lordship
my
wants us to
argument is
continue
21.
another day, I have no difficulty.
25, 22, 21. That's it.
No.
All the three.
Why I wanted another
Yes.
day is we wanted to gather all
Yes.
your files in a proper
Correct.
form
Right.
before we proceed to
Right.
dictate this
My lord,
order.
before we conclude
So
further,
there is only
may
one
I just
thing to
draw
be
your
added
lordship's
here.
attention to one paragraph, my lord.
Of?
That is, my lord, of the JVSPA.
Uh,
Firstly, your lordship rightly noted that JVSPA was with a company which does not exist any longer. Kindly see in the JVSPA, my lord, what was the purpose of JVSPA? Page 7.
uh,
Kindly see page 7,
uh.
clause 3,
Article 3?
article 3.
Hmm.
Yeah, I will. Now, my lord, article 3, the purpose of this joint venture and share purchase agreement to set forth the terms and conditions under which MHPP, that is the Indian company, will function in accordance with the memorandum and articles to be amended so as to reflect the terms and conditions of this joint venture and share purchase agreement. So this is a blueprint for amendment of your articles. You incorporated this condition in the article and subsequently removed it. So JVSPA is binding on an independent shareholder only to the extent it finds its way into the articles.
What's your point? It is not amended.
It is not amended. That condition is not incorporated in the memorandum.
Why you didn't raise this point earlier?
My lord, I have said so in my
No.
submission. Yes,
no.
your lordship is right, my lord. I have not elaborated on this point so far. My lord, each time we go through the matter, my lord, we find some new point.
We've amended a lordship.
So, my lord, under the amended articles, let him show any such condition wherein he can decline the application for, my lord, registration of shares on the ground that you are a competitor.
No. We amended this. I think you have to read the other articles.
Yes.
Article at page, Article 9, page 12.
Yes.
There was 9.3, adherence to the contractual documents. Lordship will kind of have 9.3, adherence to, I just want to read that. Because
Actually, you should have read the second portion of Article 3. The purpose of the parties in executing the joint venture and
Yes.
share purchase agreement in accordance with the desire of the parties for enhancing economic cooperation
Yes.
and technical exchanges is to gain competitive market position in terms of quality and price in the field of designing and manufacturing hydropower plant in the territory so as to raise economic results and ensure profitable operations as well as satisfactory economic profits for MHPP.
Yes.
So, This was a marriage of convenience of
That's right.
specific nature with Macromedia SA.
Yes. And the last submission.
Both of us bid for the same contracts.
Now,
We
my
did
lord,
it today.
my learned friend has tried to my lord, cast a cloud on the ratio of V.P. Rangaraj by reading only one paragraph. I am reading the second part of the same paragraph. Kindly see page 714 that my learned friend relied on, page 262. 262 my learned friend has read. Kindly see 264 and 265. Just 5 lines, my lord, and I am done for the day. Shareholders can enter into any agreement in the best interest of the company. My lord has that? Para 264 at page 714.
264.
Yes.
Shareholders can enter.
Shareholders can enter into any agreement in the best interest of the company, but the only thing is that the provisions of SHA shall not go contrary to the Articles of Association. The essential purpose of SHA is to make provisions of a proper and effective internal management of the company. It can visualize the best interest of the company on diverse issues and can also find different ways not only to the best interest of the shareholders but also to the company as a whole. In Shanti Prasad Jain Kalinga Tubes, this court held that the agreements between non-members and members of the company will not bind the company, but there is nothing unlawful in entering into such agreement for transferring of shares. Of course, my lord may kindly mark this, it will not bind the company. Of course, the manner in which such agreements are to be enforced in a case of breach is given in the general law between the company and its shareholders. A breach of SHA which does not breach the Articles of Association is a valid corporate action, but we have already indicated the parties aggrieved can get their remedies under general law of the land for the breach of that agreement. Now, my lord, this can't be a condition precedent. You allow me to become a shareholder, thereafter if you think it is a breach,
This is what I said. I didn't read it, but when you see, this thing into the best interest of the company, I said that when the company, they can go to finance, they can do anything. The only conclusion shall not go contrary to Articles of Association. To make provision for effective internal management. So new contracts can be entered into. But again, Shanti Prasad, this is another famous judgment. Kalinga Tubes, Shanti Prasad judgment that agreement between non-member of the company and members of the company will not bind the company, but unlawful entry into agreement for transfer of shares. Of course, the manner in which an agreement is enforced in general law between company and the shareholders. A breach of SHA which does not breach the Articles of Association is valid corporate action, but as you know, the parties can get remedy under general law of land in breach of the agreement. So it is standalone.
Lordship may take up all the documents. We will limit ourselves to only few documents of the shareholders agreement because my learned friend said that it was not incorporated. The shareholders agreement did provide for this clause, and we did amend the Articles of Association to incorporate that negative cooperative law, which my learned friend said it was not there.
That was subsequent.
No,
even,
no.
2012 itself.
2012 itself, the 9.3 adherence to the contractual document, there is a clause. Page 12 of my document, Lordship compilation.
Anyway, we'll do
Yes,
it.
that's
We
correct. Therefore, I
will
don't
hold
want
it.
to go beyond the time.
Lord, then your lordship would want us to continue whichever day, my lord.
Yeah. Today is 7th. How come it is? Today is 6th. Okay.
Today is 6th, my lord.
Yes, 13th.
30. Very well. I'll be here.
Just record both councils.
On some difficulty of that teacher. I will.
You are on a partner, na?
13th,
You are a partner,
I am
na?
in a partner there, Lordship.
Where?
Nclt.
This will have an item 1.
No, that's what I'm saying. We reached.
14.
So you finish that and come because
Huh.
we
I
will.
know.
We
Yes,
want to
then I'm
go
very
ahead
well.
with
Not
this.
I'll be
Finish
here.
that and come.
I'll be here.
Grateful.
Grateful.
Deep obliged, Lordship. Today
Thank you.
We had a pilot project, so we
I think today we had a lot of time, my lord.
Can you continue 13th?
Now on the next day, I think, my lord, we only have to summarize what we have already
I don't think it is
taken your lordship
required,
through. Yes.
but I'm just keeping it for the safe side. Nothing
Very well.
more. I don't think.
Extremely good.
Did you note down the dates on which they gave their test? So many charts were given today.
Which is Mr. Makkar.
Sir, close please.
No, we'll hold, continue, 1 minute. Why are you not? This alone you put it together. You ask them to take this separately, they will get confused.
Sorry, loose papers.
This, this you take it up separately. Yes, sir. You are discharged. Yes, call the next case.
Okay, sir.
No, this. No.
Item number 4, Manjeet Singh Basi versus Continental Construction.
Milords, I've been served with an application late last night,
Yes.
which I wish to file a reply. They want to modify a consent order, which has been in force for many years now.
Okay.
And the application is to modify that. So, Milords,
All
please
right,
give me
we'll-
a week's time to file a reply.
13th? That we'll see that. What's your good name, sir?
Milords, I'm Abhimanyu Bhandari. I'm representing
Seems
Mr.
to
Chandra
file his
Verma.
response in ICA 204, is it? Yes. list
204.
13-7. 13-7. Call the next case.
13.
Deeply obliged.
Item number 5 and 6, Vibhor Gupta versus Ultra Build Construction. Side में दिख रहा है.
Anybody there?
So time for I have 1, 11 and 13 in item 6. There is an IACA 242 of 2020.
Hmm.
Consular service is affected.
Okay, await service. List and give a longer date.
Okay, sir.
Next August end.
We'll have it on 31st August. All 3 items. Item number 5, 6, 7 will have it on 31st August. Item number 8, Vibhor Gupta versus Rajesh Bilkon. Oh, this
These
is
are
also
all
with
clubbed
it.
together.
8
I'm
also,
before-
okay.
Yeah.
Item number 9, Laguna Holdings versus Eden Park.
Yes. Can we have it in the afternoon then? Post lunch? Okay. What about you, madam? What's his name? Is he there?
But nobody is there, madam.
Blood, I'm here, blood.
Yeah, he's there.
Well, I'm here, blood. I'm for the
I
respondent.
see him here, but
I'll just
Blood.
bring him, sir.
Blood. Am I audible, blood?
okay. We'll hear you in the afternoon, post lunch.
Yes,
Passed
sir.
over. Passed over.
Item number 9 passed over. Item number 10, Vikram Kapoor versus Atlas Cycle.
Some order. We have to press again. No, this is.
Looks I'm for 15 and 17 works. I've just been engaged. Looks this is an application. Looks seeking for. Looks will kindly commit with some time. Looks just let me continue.
So if you are new counsel, take your time and argue the matter. We are not forcing you to do that.
But Lords, I'm just seeking for a short accommodation,
No
Lords.
problem,
That is
no
all.
problem. Give it
Lords,
to
the
me.
Nclt appeal is coming, Lords, on the 20th. Lords, may I have it kindly after that because the main order is under challenge.
Applicant counsel. What's your name, sir?
Arjun Sayal.
Arjun Sahal in IN CA 122-6, another date. Hi, sir.
So,
Your Lordship, Your Lordship,
So who has filed this application?
Who is the applicant? The CA number
Your
22.
Lordship,
Where is
the applicant is the suspended board of directors.
No.
Sorry, the new board of directors. My bad.
Appointed a fresh board of directors in this
No,
matter.
who are
because
you?
they
Yes.
are the applicants.
Your Lordship, I'm being led by Senior Advocate Virender Ganda in this matter. He's on his legs before Nclt. A short passover may be granted in this matter.
Will you keep quiet then? Because we are asking who is the petitioner.
Your Lordship,
New board is the petitioners.
yes, sir, the new board is the
board.
applicant.
Applicant is the new board, my lords. Your Lordship said it by the 6th of December order, my lords, have removed the existing board. It's been replaced by a new board, my lords. So they have filed this application under section 2. And my lords, I am seeking for time on behalf of the ex-directors, the ex-board, my lords.
You argued as if you are filing this
the
application.
applicant.
I
That is what you
indicated I am on
do.
behalf of 15 to 17.
You have to come
my
this
lords.
side.
I'm always-
You are on the wrong side and making a wrong
15 to 17, my lords.
representation.
I indicated in the outside.
Move this side, move this side, come this side. Who's filed this one?
Your Lordship, the new
122.
the new board has filed the application. It was
Madam, are
filed.
you representing new board?
Your Lordship, I'm being led by Mr. Virender Ganda. He is representing the new board.
Why is he not here?
Your Lordship, he's on his legs before Nclt. He will be here. Yes, sir. Yes, Your Lordship.
My lords, I'm seeking for an accommodation just for today, my lords, if possible.
No. Yeah, this will be passed over.
Otherwise, my
then.
lords, the pleadings, I'm told, my lords, are
Pass
not
over.
complete in any case, my lords.
Pass over.
Lordships may give us a short
Please, Your
accommodation.
11.
Item number 11, Ajit Singh versus Bandari Builders.
Malaja, I am there for respondent number 2, 3 and 10. Malaja, it's a 2015 matter. I was supposed to file the written submissions. Malaja, because of the e-filing, I am unable to file. I am a new advocate in this. Neither
What's
my
your name, sir?
Gaurav Nclt.
Just put that name. Appearing for the
Respondent
new
number 2,
counsel
3 and
appearing
10.
for respondent.
2, 3 and 10.
Seek some time to file the written submissions online. It is requested to be in August.
Because I have also, in fact, this is a disposed of matter.
we'll
Justice Sikri was appointed as the liquidator. He has filed an application for discharge. Your Lordships had asked us to file written submissions on the limited aspect of how to move forward. I have filed an affidavit giving my lords my suggestion.
Affidavit of what's the name?
For the petitioners, my lords.
Was it Suman Patra?
No, he appears for the liquidator.
My lords, I am appearing for the
Then
applicant
whom are you?
who's the liquidator.
Because I am for the petitioners in the original petition, my lords, which came to be disposed of by this tribunal.
The application
The
for
original
Nclt is also,
petitioners.
I believe, there. It's on the same issue.
No. What is the previous order?
Sir, he is the original petitioner. Mr. Suman Batra as the liquidator, on behalf of the liquidator, moved
You
an
wanted some
application.
modification.
So
Yes.
His point was to be relieved. The liquidator wants to be relieved, Mr. Justice Sikri. What you had asked for, and he was opposing it. So your point was that if the liquidator is relieved...
Remove, what is your way forward? You have filed your affidavit, is it?
Malaja,
I
I
have
have to also
filed
file.
my affidavit.
The learned court. What's your name, sir?
Diggaj Pathak.
Pathak counsel appearing for the one of the parties. One of the parties states he has filed an affidavit dated
Yesterday, my lords. I filed.
dated 5/7/2023, which is not on record, no, as of now.
Yes,
Before
sir.
that,
Yes, sir.
list those affidavit in file number. You take, give the number, file number. List this on not on 13th. I will give you a date.
September.
Thursday. 24/8 is okay.
Okay, sir.
24/8.
24 August.
24/8.
Much obliged.
Grateful.
Much obliged.
Item number 12, Anil Kumar Jain versus Vardhaman Roller Floor.
Anybody there?
Anybody there for item number 12? Anil Kumar
That
Jain
was
versus Vardhaman Roller Floor Mills.
I beg to differ for respondent number 3 in this.
None for the
Anybody?
petitioner, respond number. Huh?
New counsel was engaged in for the petitioners. They were to take
Were
the
they
instructions
absent?
as per the last order.
Anybody for the petitioners?
Let's see the last order. when you do. Last order, sir. Sahil Yadav. On 24/2023, the new counsel Sahil Yadav appeared and states that He needs some time to get instruction. Today the matter was called none appears for the petitioner, dismissed for non-prosecution.
इसमें all CS कर देना. Item number 13.
So and so appears for respondent. Right. This order has been passed in the presence of Nclt Sharma, who is appearing for respondent number 3. Yes.
Item number 13. Avnish Gupta versus Great Balaji Finbase.
My lord, time for the petitioner and matter is listed for final argument, my lord.
Yeah, sure. Please tell me, what do you want? Who's for respondent, sir?
Yeah, I appear for the respondent.
Yeah. Have you given the date chart?
Just twice your lordships has directed the petitioner to initiate that. He's not filed it. Your lordships last
So
order
where
says.
is your date chart, sir?
Lordships
Your
last order
submission.
says, if not filed, my lords, your lordships will proceed on the basis of documents on record, my lords.
Okay,
Because-
passed over. We'll hear him. Let him argue. Sir, your case is passed over, sir. Please argue in the afternoon.
Okay. Item number 14. Naresh Gupta versus Anupam Mahajan.
Yes, sir.
Lordship, essentially one application has to be looked into. It's an amendment application. Lordship, there are two challenges. One is my reduction of the share capital and removal from the board. Now, what had happened pursuant to my Lordship's order of 4th of February 2019, Mullen and Friend had filed the document relating to the transfer. So what has come out from the transfer, Lordship, exactly what exactly they did. One. Number two, the parties in whose favor the transfer has happened. So we have put in an amendment application 1819 of 2019 and we have paid for two things. One, those three people who are the transferee, they being added as a party, one. Number two, additional grounds, Lordship. These are the amendments I have sought for. And before that, Lordship, as you pointed, this one a very strange case. We have also put in an application earlier 754. It's one of the cases where respondent company is not being made up party. It's very unfortunate. In 241, 242.
So you have any objection to this?
Lordship, to respond number one company to be made a party, I have no objection, Your Lordship. He is making transferees as a party. Nobody has to go to the transferees.
Yes, of course. The formally has to
So
be allowed.
754 can be allowed?
Yes, yes. Making respond number one as a party can be allowed.
And so should the transferee also.
Is that the application?
There are two, yes.
See the prayer, sir.
754, that's the prayer.
Let's see the prayer.
754, that's the prayer.
Can be allowed.
Only 754. 754, the prayer is array the company as respond number 5. Yes, sir.
Yes, Mr. Nagesh appears for respondent number in that application.
Respond number 5.
5. Who is the contesting respondent?
It's the company, Lordship.
No, sir. See, he is asking somebody to be added as respondent number 1 in the main petition.
No, he wants respond to be added as respond number 5. That's the prayer, Lordship.
Respondent number?
5. Because respond number 1 are the shareholders, directors, etc. He did not implicate respond number 1 as the company as respond number 1. So now he wants to add as respond
No,
number 5.
company was not a party in the main petition.
Yes, to begin with.
Acha, according to the applicant, this 752, the company was not made as a party respondent in the main petition, and therefore this application is filed to bring on record the company as the respondent number 1 in the main petition. Is that correct?
No, he wants, because there are already 4 respondents, Your Lordship. He wants to
So
add.
it will be added 5.
5, correct. That's what it
The
is.
company to be added as a respondent, accordingly application is allowed. The company will be added as respondent number 5 in the main petition.
But Mr. Nagesh,
No, Lord,
the CS 754 of 18 which we have, here the prayer is different. Here the prayer is the waiver of
No, that's
section
755.
244.
That's 755. my
There
lord.
it is 754.
That would be 755.
That's 755.
But this is 7544.
I'm so sorry, Lord. I think
Therefore,
754.
when your Lordship asks what is the IA number,
No, then
I
it will be a
issue to my
problem
brother.
because
754 and this is the
So
waiver
our number is right, sir.
Our number is
so
right.
we go by our number
go
when
by
we
our
pass an
number.
order. Waiver of what?
So waiver of section 244. That minimum 10% or
Yeah, Lordship, that perhaps may not be required. I'll tell this
Then
was
see the other prayer, then probably.
755. 755 is the law petitioner to array company. This is
It's a 755.
755.
So not 754, 755. You
Fair
have
enough.
noted wrong.
I stand
755
corrected.
is allowed.
I stand corrected.
So sound waiver, there is another one. That is 1819 notice. 1819 notice due at the end of August.
Okay, sir. 31st August.
Grateful.
Item number 15. Hotel and Restaurant Federation versus the Federation of Hotels.
What happened?
Your Lordship, may I seek a short adjournment as the petitioner's mother is in hospital since last few days. Any short adjournment, Your Lordship, may leave fit.
Compliance report, no? That we can take on record. We'll take on record. And what is the name of the counsel, sir?
Advocate Mr. Kaustup Singh, sir.
Somebody says the personal interview is not able to come, give it in September end, madam.
Okay, sir. We'll have it on 21st September.
Highly obliged, Your Lordship. Highly obliged.
But I think it was over now, Mr. Nagir. So what remains now?
I think they wanted to file that Your Lordship appointed Mr. Satyanarayan as the observer. That report has to come on record. I think that is.
Okay.
So this is.
Can we close the contempt also?
I don't know. That is, I have not briefed.
Why not we close the contempt and close the case? Why do you keep, what is remains here?
Your Lordship, any short adjournment, we are unable to take instructions from the
keeping it as a
petitioner.
Damocles sword on this.
I have not briefed.
No, Your Lordship, as petitioner's mother is in hospital, Your Lordship, so that's why we are unable to take instructions.
No, you put it on 13, we'll close it, otherwise we'll be hanging.
Okay, 13 July.
Or we can do one thing, close the contempt with the option to revive if the contempt survives. That's all. Now, in the CP in this case was allowed on 30/8/2022, and has been, the order of this tribunal has been confirmed by the Honorable Nclt and also by the Honorable Supreme Court. However, we do not want to keep the contempt alive. We close it with the liberty to the petitioner to revive if the cause survives. Contempt stands closed. Was consign it to the records. IA is taken on record. 223 is taken on record. Yes. 16.
So date comment only. Okay. Item number 16 and 17. Ronak Textiles versus RN Techno Build.
Please, Your Lordships, I am appearing for the petitioner in this matter, Your Lordships.
Your Lordship, I am appearing for the respondent.
In this case, Your Lordship, the respondents had filed an application seeking referral of this petition to an arbitration, an ongoing arbitration. I am objecting to that. Your Lordship, before the petition is argued, that perhaps will need to be argued. That is one aspect.
I see a number 201, is it?
Yes, Your Lordship. The other aspect is, Your Lordship, that the respondents were required to file their pleadings, Your Lordships. That has, it seems, not been done yet, Your Lordship.
E-file the respective including. Oh, this is an old case. They have not filed.
Yes, Your Lordship.
No, you have to see the order. You are not telling me, my court master.
Okay.
What? Okay.
Your Lordship, we have done it. The respondents have not done it.
They have to file the portals.
You tell me what I have to record, because either they have filed or not filed. You have to only report.
I'll just check and tell you, sir.
Respondents have not filed, Your Lordship. That's what my understanding is, Your Lordship.
Oh.
We have filed it.
You have filed it, is it?
Yes, Your Lordships.
Now do
in all the three matters, Your Lordship, 16, 17 and 18 also.
Okay.
Dekho.
One last
It's
opportunity.
there,
One last. He says respondent has not filed. Filed or not filed?
Respondents have not filed, sir.
Then you said it's there.
No, petitioners
Petitioners have
filed, sir.
Petitioner counsel states that he has refiled all the records as directed by order dated 15/12/22. Respondent appears to have not complied with the order dated 15/12/22. He is given one last opportunity to comply with the same. Full stop. This turn, give it in first week September.
Okay. Then 14 September.
Very well, Your Lordship. This will be the case in 16, 17 and 18, Your Lordship. Also. Item 16, 17 and 18.
Item number 19. Rishikesh versus Urban Club.
My lord, in this particular case, in CA 2609,
yes, sir.
my lord has ordered for. Am I audible?
If my lord permit me, should I make my submission, my lord? The white order dated 1st of June 2023, there were two directions, my lord. First direction was in regard to CA Avinash Gupta, that he has to make an appropriate application regarding the work entrusted upon him, my lord. And there was a second direction that notice should be issued to us so that we can make an appropriate reply, my lord. The first application we have not received from the CA Avinash Gupta, my lord. And secondly, no notice.
The reason for that being is, my lord, that the respondent in this particular application has not provided the invoices which he has admitted in para number 6 of his reply at page number 7 and 8, that being the operational head, he is having invoice and bills, but he has not provided the same to the independent auditor, because of which independent auditor is unable to provide his report. So we again request that kindly provide the copy of all invoices and bills so that we can also file our rejoinder and the auditor can provide his report and make the situation convenient for everyone, which is in interest of the company.
My lord, one thing I am unable to understand, that he is one of the respondent and he is making a statement on behalf of an independent auditor. How he can make such a statement, my lord? He is a respondent in the matter and he is making a submission on behalf.
Mr. Avinash Gupta.
Mr. Avinash Gupta, the chartered accountant. Are you there?
Then give a date end of
No, sir.
September. For appearance of in lieu of the order dated 1/6/2023, we require the assistance of Avinash Gupta, chartered accountant, who is not available today. The counsel for petitioner respondent are present through VC. List again, give a date, first week of September.
Then 14 September. 14 September. Item number 20. Asian Infratech versus Energy Infratech.
May it please, my lords, I had filed a application seeking certain urgent measures, my lords, wherein my lords was pleased to issue notice on 11th of May 2023.
We will hear it post lunch.
My lords, one small request, my lords. My lords had issued notice. Today they have served the reply, my lords. I need to rejoin. Although they tell that they have served me on 10th of June, I have not received, my lords. I am not joining issue. I just need 6 days, my lords, to rejoin certain factual issues.
6 days, 7 days, 7 nights is a
my lords, 1 week, my lords.
movie, but you want 6 days and 6 nights.
It's a very short rejoining, so it's all.
Served them on 10th of June, the day I
My lords, I am not joining issue at all, my lords.
He did say that, sir. Why are you wasting your time? Okay, heard. Put both their names. Reply has been filed and served recently, so the petition council seeks some time to file the rejoinder. At request, we'll put it on 13th then. 13th, yes.
Okay, 13th July.
Much okay.
Item number 21. Anil Garg versus Adastham Township.
21
and 22.
Readings are complete. The 241, 242 petitions, Your Lordship may have it on any day as per Your Lordship's convenience of the argument.
It has to be argued.
Obviously.
We'll file a written submission.
Can we just see the way you are prepared?
Your Lordship, unfortunately, they need
Have
to be
you
still filed.
given it to the?
No, Lordship, they still need to be filed. I don't think both sides haven't filed them yet.
Then that is what I want. Why don't you give it?
We'll
Then
file
at
that.
least we will know what your case is.
Yes, Lordship, we'll
Okay.
file that.
In terms of the earlier order, both the council seek some time to prepare the brief notes of dates and events and brief submission of the case. Then give it end of August.
September.
End of July.
July, yeah.
என்ன
Okay.
டேட் இருக்கு எவ்வளோ இருக்கு பாருங்க.
27th போடுவா.
27 July.
27th July. Item number 24. Shivraj
request.
Gupta
At request.
versus Hansraj Gupta.
Jane at request.
This matter, Your Lordship
request.
had. This matter, Your Lordship has referred to mediation of justice and law. The mediation is still pending, my lords.
Madam Pooja Saigal states that the mediation before Justice, Honorable Justice and former Judge Midali High Court is continuing. Mediation is continuing. We'll list on September end.
Yes, sir. We'll have it on September.
Who is it echoing?
It's echoing. Item number 24. PP Jewelers versus LR Builders.
Lordship recollects on 25th May, there was an issue about the petitioner number 2 not willing to pursue this matter. The Lordship said that, so I think to somebody will...
My lords, I am appearing on behalf of petitioner number 2. We had initially moved an application which was rightfully disposed of for lack of proper authority. Thereafter, proper wakalatnama has been filed, but we have never pressed for this. We are supporting the petition.
So you are on board?
Yes, sir.
Petition number 2. 2 is now on board.
Now on board.
It's okay, no
Yes,
issue.
Lord. We have.
And now,
Your Lordship, pursuant to Your Lordship's order, we filed a list of dates, everything is on record. Your Lordship can set it for hearing now.
Who's
I'm appearing for respondent numbers 1 to 6.
1 to 6? Would you be arguing or some other
I'm
counsel?
being led by Mr. Gaurav Mehta.
Gaurav Mitra. Then we'll have to keep a quiet day. Achha. Petitioner, Mr. Nagesh appears for the petitioner and counsel on record. What's your name, madam?
Kanika Singhal.
Says that Gaurav Mitra will be appearing for respondent. Dates and events have been furnished by both sides?
For the petitioner, we filed it.
Petitioner dates and events have been filed by petitioner counsel. Respondent counsel seeks some time to prepare the brief notes of argument. First week of August?
Yes, yes.
First week of August.
Lordship, one line,
10th
Your
August.
Lordship, because Lordship's last order of 25th May says whether petitioner too wants to pursue this matter. Now Your Lordship may say that he wants
Acha.
to.
The counsel, what's your name, sir?
Karan Khanna.
Karan?
Khanna.
Khanna. On Wakalat.
On Wakalat.
For petition number 2. Confirms that petitioner number 2 wants to pursue this matter along with other petitioners.
Great.
The same is recorded.
Grateful.
We'll have it on 3rd August. Item number 25, Praveen Gupta versus Wingro.
Please, my lords. My lords, this is my application. This is for withdrawal of the CP. The parties have reached a settlement.
All parties, the copy is there?
Yes, the settlement agreement is on the record at page number 8 of the application.
Is it on DMS?
Yes, yes. Lords, we have also hard filed it. We've also hard filed it.
Please pass it on because they don't have that. When did you file the hard copy, sir?
Day before yesterday.
That's the problem.
This is the settlement agreement.
IA 226 of 23 has been filed with the following prayer.
Your Honor, in this I'm appearing through VC in this.
Do you confirm this application, madam?
Yes, Your Honor. Yes, Your Honor.
Prayer B can't be granted. You will only grant prayer A, withdrawal settlement. Suppose he doesn't pay revival, you have to file fresh. Yes, prayer A.
We are requesting for leave.
You file a fresh one if the cost survives. Prayer A alone is allowed. Anyway. Yes, take this. Then 26.
Item number 26 to 30,
There is a
Union of India
Put
through
both their
SFIO.
names, sir. Jai. Put, Madam, she's on BC. Put his
There is an
name.
attendance slip in the file. Can I please have it for 1 minute?
Attendance slip.
उसमें देखो attendance slip
हाँ.
लिखा होगा.
Wait, what's you written some important phone number?
No, not at all, Your Honor. Thank you so much. Highly obliged.
Okay.
Much obliged, Your Honor.
Yes,
item
next.
Yes, Your Lordship, these are those Adarsh matters. These matters have come for transfer from the other NCLT branches. Your Lordship, we made an update with regard to, just pass that other copy. With regard to all these 6, there was 7 petitions altogether, including Delhi. 6 had to be transferred from different benches. Your Lordship, some of them have, most of them have come, only 2 are remaining. The hard copies have not come, so they've not got the new TP number. The rest all
So
are.
we'll wait for that. We'll
Yes,
post
Your
together.
Lordship, also, Your Lordship, all these matters are coming up on 13th August. Because last it was listed on 27th and it's coming up again on 13th.
13 July.
13th, sorry, July, yes.
Madam.
Soft copy has to be filed.
No. As a president, I have ordered for transfer of
Yes,
this
sir.
case.
Yes, sir. Yes, sir.
Okay. So that's what I'm saying. We
Yes,
can't
sir.
pass an order in the bench.
It's a full bunch.
There are 5 of them.
No, Your Lordship, 6. 6 from in this, Delhi is 7.
Serial 26, 27.
Madam
28,
Sri Lakshmi
29,
states
30.
that few more petitions are required to be
26 to
transferred from
30,
other.
so because Your Lordship, 2 have not got the TP number, so that's why they may not be
No,
listed.
madam, I will say few more petitions are to be transferred to the principal bench as per the order of the president.
Yes.
So await those,
Soft copy has come, only hard copy has to come.
We'll take that. Okay. List again, end of this month. End of this month we'll have.
This matter is
And the caption listed for dismissal may be removed.
Why you listed?
They were not
They were not there, sir.
Your Lordship, actually on 31st it was, we had no information it is getting listed.
Okay, remove
So
the
we were
caption
not
for
aware.
dismissal. Okay.
So Your Lordship,
And
on
this is
13th
coming up
also
13th
these
July,
matters
sir.
will get listed? Or?
All these matters.
13th July. They will change that to, or put it in first week of September if there is a date.
First week of September, then it will go to 14th September.
14th September we'll have all together.
Your Lordship,
14th
these
September.
matters,
All these matters on 13th July also will transfer to 14th September.
because much obliged.
इसमें लिख देना 13th July date cancelled.
Why did you cancel? That will come on that day, we'll transfer it to.
Because Your
14th.
Lordship, there are other, the Delhi petition has some applications, the official liquidator's application is there. So
Madam, you don't interfere with 13th July, madam. Just put this case to 14th September. Today you're gone bonkers. Yes.
Soft copy, they have to file. Sir.
Soft copy has come, hard copy has not come. That's what she said.
just give
She
one,
says,
we'll
but
give
some
one
of
list
the
to
soft
ma'am
copy
also.
we
One
don't
list
have,
to
sir.
ma'am.
Madam Nclt, all these 26 to 30, these 5 petitions, have you filed the soft copies? They are there on the DMS?
Soft copies are there.
On the DMS?
Are available. The hard copies, in fact, Your Lordship, what I have passed,
sir.
we have the acknowledgement receipt is there of those NCLT,
Cost listing
the other NCLTs where they have transferred the file. It's not received here, only the hard copies.
Direction
are-
of the registry to be complied with for submission of documents. That's all. Leave it like that. Call the next
Okay.
case.
Item number 31, Franchise India versus ASR Market Venture.
In the IA, the pleading has been completed.
There's no IS, what is it? Number?
My lord, IA has been filed 65.
107.
107. Yeah, okay. Dismissal of the city.
Yes, my lord. We filed
That's
our
okay.
reply, and
That's
the rejoinder
okay.
has also been filed. And
Rejoinder.
thereafter, we have been directed to file written argument.
Argument,
and
okay. We'll take it.
everything
up.
is on the record, my lord.
14 September report.
14 September.
14 September. Item number 32, Union of India through Regional Director versus Kornosti.
Lord, I seek to appear virtually, my lord.
ASG, sir?
Your Honor, I am for
Lordship,
serial number
Madam, you have
32.
not
I am
allowed him
requesting
here.
for a password.
He's there, sir.
Then you pass an order then. I said my video is not there.
Lordship, I am requesting for a passover in serial
That is
number
not my
32.
Yes, sir. Yes.
Lordship, on the last date, Your Lordship asked all of us to file an affidavit declaring the assets, Your Lordship. I'm appearing for 97 to 101, I filed it.
So can we just record it then?
Yes, yes, Your
ASG, sir, it appears that Mr. Nagesh appears for
97.
97 to?
That's the company, Your Lordship. So we filed that because we directed.
No, you gave a number, 97 to?
97.
Or 97, and affidavit has been filed complying with the first order.
The Lordship last order, company with the first order.
First order. So, is it there, Mr. Kurup? Have you checked that?
Manoj, we have not received that from the.
See, that's a problem because.
We've sent it on. Anyway, we'll give a copy, Lordship. We don't want. We sent it by email on July 3rd.
3rd July, okay, it's recent, probably they would not have passed it on. So,
I'll get it.
all others still will reiterate that so that they can comply with that direction. Any other thing. Now, what remains now?
Now, Lord, there is some constructive narrative that I have to respectfully place before the Honorable Bench.
Are you able to see ASG?
Yes,
sir?
yes, we can see it.
There, okay. All right, yes, sir.
Lord, there is some constructive news, my lord. It's in 4 parts.
Sure.
Part number 1, my lord, those intermeddlers and enthusiastic people who used to go to the High Court upon every order, they have been now discouraged by the High Court, my lord, from coming there, and they have been told to withdraw their application. This is news number 1.
Thank you.
I'm so obliged, my lord. I could see the sensitivity of the matter and the issue, my lord, and I took it up in right earnest, along with Mr. Kurup, who always guides me. Now, my lords, news number 2 is this, that in order to obviate and facilitate, my lords, the process here, we have formed a 4-member committee, which will go into, my lords, all the minor issues that that are troubling, my lords, the petitioners, the respondents, and in turn, my lords, trouble your lordships. So those of such issues which can be sorted out, those will be sorted out, my lords. In fact, a report has been made. It has been given over to the secretary. It's a recommendation. We'll get back to your lordships. I think 70 to 80% of the burden will be, my lords, over.
Thank you. Thank you.
Yes. The third is, my lords, that insofar as your lordships compliance is concerned regarding filing of replies to the main company petition, those replies, my lords, we are getting in bits and spurts as late as on yesterday. So let that process be complete so that we can, my lords, comply with the Honorable Tribunal's directions and come back. So this, my lord, is what I had to, my lord, submit. And then we can, my lords, on the next date, come back with more resolution. And there is one application, my lord, which we asked for the my lords, the appointment of Mr. Sidil Sasi. That is, see, I'll just give you a lordships. That can be done, my lords, 356 of 2022.
356. Okay. Yeah.
This is under Rule 11 for the appointment of Sidil Sasi
as
a nominee director. Yes,
can allow that. Take the day.
Yes. Your lordships had in fact allowed it, but for some
that is
reason
between
it's not
petitioner and us. You have no role in that. Sorry. Yes. Take that IE, please.
IA number 356 निकालो 356 दिखा दो
No, let the petitioner say something before you can answer all this. Yes, sir, please go ahead. Where is that IE?
Yes, my lord.
356. Please open that in the DMS.
356.
The appointed nominee director as intimates to represent the board of company. Okay.
In fact, your lordships had heard this application, agreed with us, but somehow the order sheet is not showing, my lord, the appointment of Sasi. But I'll just recapitulate, my lord. The point is that companies have to function, and companies need some funds for dispersal. Now, the way out and the constructive way out is that if the Honorable Tribunal were to, and the Tribunal asked us, my lords, to nominate a person, is ISS Sidil Sasi as a nominee director to represent the Union of India, so that there is just that watch on the dispersal, so that the main order and the usufruct and the substratum of these applications and the petition, my lords, does not get disturbed. This is just
which paragraphs of the petition have you given the reasons for this request?
Yes, my lord. I'll just give you a lot. Reasons. Para 8 and 9, my lord.
8.
Paragraph 8 and 9. Lord, he is the Additional Director General in the Ministry of Corporate Affairs.
Okay.
So, responsible person, my lord.
What happened?
Senior and responsible.
Sir, the number of paper is like a wall on the left side of this court hall.
No, that is what we wanted to demolish, my lord.
So to find your application itself, these boys are fiddling through big size. Anyhow, we will look into it and pass orders in that.
Yes, that's paragraph 8 and 9. That's all, my lords, in so far as today is concerned. I'm so grateful. And Mr. Nagesh will give that affidavit to Mr. Kurup, so we'll look into it.
Have you? No, no. 356 notice has been issued.
We have to check, sir. This one.
Lord, just a minute, Lord. I'm so sorry. Lord, your lordships may just note, Lord's one judgment in aid of the order which we had cited, but just to repeat. Lord, this is 2022, volume 8.
Yes.
SCC, page 749, Upinder Singh versus Unitech. Lords, their lordships of the Supreme Court say this, quote, the purpose of having an independent and professional board of directors to manage the company is precisely to obviate serious problems which have arisen in the business of the company resulting prima facie from the misconduct of earlier management. Inducting a representative of the erstwhile management will not facilitate the purpose of ensuring so and so, so and so. So, my lord, this is in effect, my lord, as I said, a passive and a active watchdog overseeing the functioning and the dispersal. And in the spirit of it. That's all.
Sharma, in which para is the averment that this Siddhil Sasi is an officer of NCA?
We have not said so, but your lordships can take my statement, my lords, that
You are saying he is additional director general.
Yes, he is additional director general, Ministry of Corporate Affairs.
My lords, if my lords may have their application.
Have you filed the reply?
My lords, I have filed. They filed a rejoinder also. Pleadings are
Where is
complete,
the
my
reply?
lords. My lord, it is on record.
DMS.
DMS में दिखा दो.
Reply.
Yes,
Huh?
my lords. My lords, I have prepared a
नहीं.
date chart also.
No, no.
If my lords
where
would.
is the reply in the DMS?
My lords, it is there. My lords, it is on record.
It's not. It's not.
It is there.
They are opening the
It
file,
is on
but they
record,
don't
my
find
lords.
anything.
My lords, it is on record. It was filed quite earlier, my lords.
No,
It
you
is there
can't-
on online. We've
Please
checked.
don't be vague. Please specific. What date you filed, you tell me.
Yes, my lords. I'll give the date.
Please open it.
Sure. I'll just
My lords,
check.
we have filed it on 8/12/2022. 8th of December,
Point from
2022.
there. I'm just checking, sir.
8th December, my lords, we had filed it.
I'll tell you it's buffering.
Application. Reply.
No.
Have you filed it hard copy also?
Yes, my lords.
What
It's
is
on
the date
record,
you
my
filed?
lords. My lords, I filed it on 8th of
It's not
December,
there, sir.
2022.
Nothing is there, sir.
No, on the DMS it is not there, obviously. Hard
No,
copy, I
it's
don't know.
there.
What is? Can you show proof you have filed?
Yes, my lords, I have, my lords. I will show the proof, my lords. It's here. We
Please
have the
give-
proof of the
please give
document
it.
loaded successfully
Please
also, and my
give it.
lords given hard copy also. It is there, my lords. My lords. नहीं वो तो submit हो गई ना.
No, don't argue with him, please.
सुनो,
Just show the seal.
वो टाइम वाला दिखा दो. CA में टाइम वाला दिखा दो.
My lords, if my lords may have their application, my lords, I have on a preliminary issue. My lords has that application only. My lords, para 2 of the application that they have filed. My lords may read para 2. My lords, they are saying that this applicant, which is the union, has filed a company petition under section 2245. My lords, my lords, the applicant has filed company petition under section 2245, 241 and 242 of Companies Act in company petition number 62 for disgorgement of assets of respondent companies and their directors. And if my lords may have the title, my lords, they have only asked for appointment in 3 companies. The companies with my lords had very graciously given us certain relief, my lords. My lords, that was Carnoustie Property, Carnoustie Resort and Coinstone Developers. Now, my lords, only in these 3, the learned ASGs, my lord, they have moved an application. Now, my lord, my humble submission is that this is not a 241, 242 application as they have pleaded. It is an application under 2245. And if my lords may please have this section, my lords, section 242, if I may please read, my lords. It says, my lords, the first line, my lords, qua the powers of the tribunal, if on any application made under section 241, the tribunal is of the opinion.
My lords, there is no application that they have made. And my lords, the 10,000 page inspector's report, there is no allegation of mismanagement. My lords, there is no allegation of siphoning. So my lords, I don't understand the learned ASG making statements that the new board needs to be replaced and equating us with Unitech, my lords. They've not said, my lords, the money that came to me, there are assets there. So there is no mismanagement. They have not pleaded mismanagement anywhere. And it is not an application under 241, 242. And my lords may also have the permission that the union has given them.
But they are under the main matter.
Sir, one second.
Is there? So that they want to nominate that. That's it.
My lords, if I may show page 209, which is permission given to the union. My lords, the permission, it is part of the main petition that is filed by the union. It's the last page of the volume 1. They say that petition under 2245 of Companies Act in matter of Carnoustie Management and its group company, I am directed that such and such subject to convey approval and authorized to urgently file the petition. My lords, this approval is also only for 2245, my lords. My lords, how is a relief and how is an application, my lords? Cursorily, and my lords may even have their prayer. Even in their prayer, my lords, they have not said mismanagement. They have not asked reliefs of 241, 242, my lords. And IA, my lords, and then saying that they have filed this petition under is on record and on affidavit, my lords, on oath, with great responsibility, I say, my lords, is misleading this honorable tribunal, my lords. The 241, 242 application has not been filed by them, my lords. How can they seek relief of under 242, my lords, where the section's wording is clear, where an application is made under that, my lords?
I got your point.
Yes, ma'am. That is qua the maintainability, my lords, of this 241, 242. Now, my lords, on the merit of para 8 that the learned ASG has referred to, my lords, that he wants to check, my lords, how the money is going, and the averment they have made is whether these companies are even functional and working or not. My lords, to my reply, which runs in 3 volumes, my lords, I have annexed all my lease deeds. There are MNCs who are there, my lords, all my maintenance bill, my electricity bill, the resorts booking, employees. There are more than 300 employees. We are getting certificate from the GST department for filing, my lords, on time. We have TDS. All that proof is already there, my lords, to show that we are working companies. Another thing, my lords, is qua regarding that whether we are shell or not. Because we are not shell companies, we have employees, we are running going concerns and businesses here, my lords. Now, my lords, for us, for a nominee director to be appointed with financial veto power, as that has been prayed, my lords, these financial veto powers would essentially mean, my lords, for resorts, for example, which is treating people with chronic diseases, my lords, autistic children also come there, my lords. My lords, people suffering from physical ailments, my lords, and it is a world-renowned resort, my lords, which could lead an independent director being appointed on our board with no responsibility, my lords, would lead to medical negligence, lawsuits, and open us to that also, my lords, which is not required, my lords. The statement of accounts, our budget is being approved by an MCO official. And my lords had directed us to file the same on affidavit, and we've been doing that also, my lords. My lords, wherein there is no power, my lords, they have not prayed in the 2245, my lords. The section is clear, my lords, at an interim stage.
Please, there's no
my
need.
lords,
I have already said that.
My lords, for me, there is a lot at stake. I have employees. I have 200, 300 employees who will lose the confidence in the management. I'll have to shut shop, my lords. Who will work? What about my resorts booking, my lord? One thing on TripAdvisor, one bad PR, my lords, and everything goes flat. I am in a rural area of Kerala, my lords, where I give employment to women, poor fishermen's women who were abused. They have employment, my lords, there. My lords, I have illiterate people to whom I have revived the rural Kerala's economy. If my resort is shut and the news goes away, my lords, I'm world's number 5 under top 5 resorts of the world, my lords. I have got international awards, my lords, for ASG to say, my lords,
how it is relevant, but we'll consider.
My lords, it is relevant because learned ASG is saying, how do we know if they are even a running company or not? The allegation is that he said that we don't know if they are running companies.
Thank you.
Lords,
Thank you.
Can I quickly address, Lords? If your
Sir, it
Lordships
is 2 o'clock, sir. Sorry, she has
My lords, my
completed
learned
her
senior is
argument,
there,
so-
my lords.
Okay.
My Lords, I've been requesting, my Lords, for your Lordship's kind indulgence. My Lords, we didn't know that this was sitting through lunchtime, my Lords. So therefore, I can be there in about 5 minutes or 7 minutes. I wasn't sure, my Lords, that your Lordships will be taking
Anyhow.
through lunchtime. This matters will be taken up, my Lords. But this is an important matter. So if your Lordship permits me,
But she has already made the representation fully, completely, because she has gone through the entire gamut of that case.
your
And
Lordships
also
don't
heard-
wish to hear me, my Lords?
we can't be hearing again, and she argued the matter. If she had wanted you to argue, she should have
My
kept
lords, I
quiet.
had requested
No,
that
that
my
request was
learned
made-
senior is leading. I did request that, but my lords were.
Made at the very beginning.
I did request that, my lords.
You
Twice,
went
thrice I
ahead, madam,
requested.
You went ahead, you addressed the Honorable Tribunal. Now let's leave it to the Honorable Tribunal.
This is not the way we treat juniors, Mr. ASG. If the junior is requesting, so let us not say that. You and I will not say that. My Lords, may I say this?
Mr. Srinivasan, she has argued to an extent that that your company is giving employment and it will be shut. What more can be argued?
It's not
It's
just
been
that.
taken to that level. There is no
No,
question of treating somebody like that. It
My Lords,
can't
may
be.
I? We are on the root cause of whether there is an application before your Lordships.
So that submission has been made.
Yeah, if that application, that application is under 224.
So that submission has been made, Mr. Srinivasan.
That is for the court to allow me to make a submission or not.
So it
Not
has
for
been
you.
made. We can't hear again and again and again over and over again.
Please don't take advantage of the fact that there is a junior. I have been requesting since the very beginning, raising my hand to be able to address the court. And therefore the court did not see me. Now that I have the court's attention, allow me please. My Lords, may I?
But I would, I normally don't, my lords, object, but this is not fair.
This is not fair. I agree with my
No,
friend.
this is not fair. The advocate has addressed. She should have said that I am being led by you.
Yes, she did.
No, but then she chose not to wait. She
No,
chose
that
to
was
address fully.
answering a question. She was answering.
No. She
You
chose to
chose to
address fully.
You chose
And
to
it's not a
proceed.
question of raising the hand. You said you were not aware of the lunchtime. So where were you? Where were your hands? You just made a statement that you were not aware that the court was sitting in lunchtime. So how could you raise your hands?
For me to be
I mean,
physically, I was informed that the matter has been taken up and therefore I logged in now. That's what I have done. So, my Lords, may I say this? These are matters which has been pending for a while. My Lords, there is nothing that is urgent that cannot wait till this afternoon, 2 o'clock or 3 o'clock or, my Lords, tomorrow. My Lords, this is a matter that goes to the very root of the jurisdiction. There is no application before you
The application.
under 241, 242. There is no sanction of the government. This is a wholly misconceived application. And to be able to obtain by an order by the side wind, as in the fag end, my Lords, is a little odd, if I may say. First of all, they have to make out a case.
I object to this phrase, obtaining an order by the side wind. This is just not done.
Absolutely, this is my submission.
What side wind? What side wind is this? Just tell me.
I did not interrupt my friend. Let my friend not interrupt me.
You weren't here, so not to interrupt.
I would have not interrupted either way. Now, my
No,
Lords,
but then please don't make such statements, obtaining an order by the side wind.
I am making a conscious, deliberate statement. This is exactly the position. The position of law is you can get this order if you have moved an application under...
That has been argued, Mr. Srinivasan. You are not arguing something new.
I wish I could call you my lord, but not yet, Mr. Chetan Sharma.
I never wanted to be called a lord.
I don't think it's quite...
But the manner in which you are dictating terms perhaps seems that you are a de facto lord yourself.
It is evident to the world at large who is dictating here.
By the way, both of you, please be informed that you are being recorded on YouTube and your conduct will be observed throughout the world.
That is right. So I will request my friend to kindly not interrupt me and address.
That's why I kept quiet, allowing you people, because this will go in the public domain how lawyers in India are practicing.
That is right, my lords, and I will request my learned friend to kindly please permit me to complete, and then he can have his say. Now,
Please,
my lords,
please file a written submission, sir, because we heard enough. So please file your written submission, we will take it up. No problem. Thank you.
Your lordships, my lords, your lordship will hear the matter.
No. You please file your written submissions. Reply is there. Your reply already. Reply is already there. You file your written.
I'm so sorry. Your lordships have held, my lords. A reply by itself or written submissions by itself are no substitute for submissions. My friend made a request. It is on YouTube. It has been recorded. The very first submission was, please take a passover so that my senior can come in. And therefore, my lord, your lordship said that let the petitioner first open and then we will hear
you
you.
can't be passing over every case. We already have passed over enough number of cases. So this is a
during
big
lunchtime,
bunch of cases, and there are quite number of lawyers waiting here. So
This has been taken during lunch recess. This has been taken during lunch recess, my lords. Therefore, we have to be put to notice. We have to be heard. I will take 10-15 minutes, that's all. But this is important. I cannot have, my lord, the government in an application which is not maintainable, foist a director, my lords, in my company without authority of law. So your lordship will have to be, I have to inform your lordships about that. Please see the application. Your lordship will see the very petition first, which is the foundation. This is an application in a petition that has been filed. Now, please see the very first petition itself, my lord. The Union of India's petition, your lordship will see.
All right, we'll do one thing. We'll continue after lunch. You argue. No problem.
Lordship, please. I'm so deeply obliged.
Whether I is in the same batch, not your lordship still be hearing it on some other day?
IA wise will be taken up or?
No. Did you not hear ASG say that he is in the process of filing replies to all of them have come. So he'll complete all that and then it can be taken up. That's how.
I have to submit one thing. Lord, I'm appearing in three IAs, that is 326, 333 and 14 of 2023. In that Lord, I wish to file rejoinder to the reply filed by the union.
That's all right. Nobody is stopping you. That you can do.
My lord, may pass this general order, the pleadings will be completed by the next day.
Correct.
And Lord, last time, Lord, I had pleaded in one of my IA 326. The Honorable Court has been pleased to exempt, not to file affidavit. Lord, in two other IAs, I was appearing through VC. Perhaps it has not come. So I'm requesting the same should continue in
Not to?
not to comply with the order. Lord,
No, we don't give an order saying don't comply with the order.
No, Lord, I'm praying that that's my submission, that till my IAs is exactly on that.
Please read the order properly. I think you're making a mistake. We never said that. Please read the order. Why should I preempt and tell? Please read the order.
That my submission and court had noted that I want not to submit my application.
Say that because we didn't say.
That's what I'm saying. That's what I'm saying. That.
So all that we will do it later on. We'll do it later on.
With great respect, if I can make submission and see
in view of the statement made by Leonard ASG that the reply in most of the cases are being prepared and ready for filing. We give them opportunity to file the reply to these applications and file it on the DMS. List the matters for hearing on the 27th July. In the meanwhile, parties are also liberty to file the rejoinder if they choose to.
Okay. Lordship, all the IAs.
If I may submit your lordship, my position is a bit different. I am appearing for respondent number 108, 111 and 114. I've been a director in a sister company. My accounts have been frozen. I filed an interim application. The pleadings have been complete. I've also filed my reply to the main company petition. So at least my CAs may be taken because my accounts have been frozen for 13 months now.
I know.
That's my only request.
But there are cases similar to that. You are not the
I understand.
Even my case is similar to that.
Then your lordship, the request is that batch may be taken up at an early date.
No, they will prepare the batch accordingly. Whoever is complete in pleadings, we will take up.
I'm so grateful.
Okay.
My lord, I appear.
Yes, Nankani.
My lords, I appear in a CA 107.
Normally we hear these cases on a Thursday.
My lords,
is that inconvenient to you?
It is, my lords. I have already filed a reply in my CA 107 to the main petition and application for deletion.
Is a Thursday. Is that okay?
My lord, so it kindly
all
hear
of
me.
you, 10th August is okay with you?
My lord, the 10th August would be a problem because the date. My lords, if I may submit with your permission, my lords. 10th August would be a problem because it's a very long date. Pleadings are complete in most matters, my lords.
Okay, 27th August. 27th July.
Pleadings are completed that.
Lordship, in fact, if I may request, I am appearing for respondents 31, 32, and I have never been involved or associated with Carnoustie or anyone else.
27th July.
I was a director in a company which was just purchased. Can I just make a
27th July, item number 33.
We will only take up 356 after lunch. Others can go.
Very
good.
33.
Item number 33, Gagandeep Singh Khurana versus
may I mention item number 11?
Let me just make a submission.
33.
My lords. In
Your Lordship, may I mention item number 11?
32, I have to
My
make
lord,
a
I am
submission.
appearing for the
Ma'am, want to mention
petitioner in
item.
item number 33.
My lord should permit me to make a submission in 32, my lord.
Lord, may allow
My
me
daughter is to get married, my lord, the lockers are sealed. Now I filed a reply about 6 months back to the main petition and the IA.
33.
And I just beseech my
Item number
lord.
33, Gagan Singh Khurana versus Bharat Health Service.
My lords, I appear for the petitioner. My lords, we withdraw the petition as the parties have reached to a settlement.
Please put it in the chat box, madam. Enter that in the chat box. Counsel, what's your name? What's your name?
Pritika Khurana, my lords.
Achha. Please put it in the chat box. Counsel has made an
Obliged,
announcement that the matter has been resolved. Petition stand dismissed. Yes.
Item number 34, Ankit Naran versus Mall Bill 12.
Restoration, we'll see it later. Yes,
Okay.
this will come on. No, that's all right. August 10th.
10th August. Item number 101, Sangeeta Batra versus Consult Enterprises. It's a new petition.
Please, Milords. Milords, between the same parties, but a different company, but same shareholders, two matters are pending before court number 2. Milords, Honorable Justice G.S. Sistani, retired judge of the Honorable High Court, has been appointed as the mediator. We are having the first mediation proceedings on Saturday, Milords. A similar order may be passed in that. I'll give details, Milords. Unfortunately, I don't have that order.
Okay, then we'll see. What's your name, sir?
Mohit D. Ram.
Counsel appearing for the petitioner wants to submit certain proceedings of the coordinate bench. Next week you put it, 13. You give it next week, we'll see.
Before the coordinate bench.
I don't know, wherever you want to give. If you want to give it to us, you give it to us. 13 July. That's all, no?
Yeah.
Please, Milords, there is a small mentioning, Milords, in a matter, Milords.
Lord, with the request of the Lord, may I mention item 12, Lord?
My lord, may I mention item number 11, my lords?
Lord, I am
for the
for
petitioner, my
I am
lords.
the newly engaged counsel in this matter, my lord. I need some time, my lords, in this matter.